Your Lordship, Your Lordship, may I be permitted to mention one Section 34 application for inclusion in Your Lordship's list? The award has been challenged by the petitioner. I'm mentioning about notice, and my learned senior friend is for the respondent as well. The thing is that has happened is that the bank guarantee that has been furnished by the petitioner is being renewed, and a substantial amount of rupees, around rupees 40 crore, is stuck until and unless the matter is heard by Your Lordship. And adjudication has been reached.
Why
Nothing.
should I give precedence to this matter?
Your Lordship,
Why should I give precedence to the matter?
the amount, because of the amount involved, if Your Lordship kindly includes in Your Lordship's list.
Challenging the same award.
Yes.
Both the claimant and the respondent, both of them have filed
Yes.
30 for each. If Your Lordship hear it out analogous.
Let it come in its own course.
Unfortunately,
No urgency.
since it's not in Your Lordship's list, that's why I was mentioning, if Your Lordship
Do it
kindly,
after 2 weeks.
2
Do
weeks.
it after 2 weeks.
My lord, may I permit?
Shall come back after this one.
As Your Lordship.
Just include one inclusion in the list would be
Inclusion in the list is the main problem after 2 weeks.
as Your Lordship.
As Your Lordship directs. As Your Lordship.
Sir, may I permit to mention some new matter? The execution application, my lord, it appear any day subject to my lord convenient.
Execution.
Let's forward.
Your Lordship, may I be permitted to mention this matter? Your Lordship was pleased to dispose of the execution application by granting us the petition to approach the competent court. Your Lordship, I'm seeking Your Lordship kind leave to take back the certified copy of the award from the department and replace it with the photocopy in order to take the necessary steps.
So go and ask the department.
Lordship, they are saying the leave is required from this court.
Problem is, you should have said that very day we could have included in the order sheet.
That was missed on my part, Your Lordship.
On the mentioning, what order do I pass?
Kindly keeps it on to be mentioned.
To be mentioned tomorrow.
Lordship, may I be permitted also to mention 2 execution applications for withdrawal?
Lordship, item number 1, 2, and 3, the matters have been settled between the parties. I wish to withdraw. This is my written instructions.
Petitioner seeks to withdraw the present petition, since the matter has been amicably settled between the parties. The present petition is dismissed as withdrawn. 1, 2, 3.
Lordship, warrants, if any, be discharged.
Interim order any? Stands. Interim order any? Stands vacated. The same thing. Any interim order stands vacated.
Now, for the petitioner, I am later Mr. Amitabh Bose is appearing to virtual.
But I'm appearing online. But this is my application for set modification of the order. The previous arbiters have been removed because they were reluctant to proceed with the matter. 3 new arbiters have been appointed. Now, what has happened? The arbitrators wanted certain clarification of the order passed by Justice Shampa Sarkar.
Order should do, no?
My lord,
But I must tell you, Lordship, the other side has telephoned me last night that there is some death of her mother or mother-in-law. I don't know. She wanted some adjournment or convenience for me.
my lord, I am appearing
Just a
for.
minute. What is the application which you have filed? Clarification?
The clarification is this, Lord. The learned arbitrator, Justice Shampa Sharka's directed that the arbitrators, newly appointed arbitrators, will proceed from the stage that was left out by the previous arbitrators, considering the pleadings completed. But there was no directions for using the oral evidence. Now, my lord, the new arbiter is saying that evidence, if you want to give oral evidence, they will have to get it clarified from the court. So that's the reason, after holding some sittings and disposing of some other pending applications, the arbitration cannot be heard out now. So that's the clarification I'm seeking for. That's whether the evidence can be given before the learned arbitrators or not. Because I'm the claimant.
Take down. The present application has been filed by the petitioner seeking modification / clarification or clarification of the order dated 18/11/2024 passed by the learned predecessor bench of this court, Honorable Justice Shampa Sarkar, right?
Sarkar.
Shampa Sarkar. Full stop. In view of the same, it is in view of the same, let this matter be listed before the appropriate bench, subject to orders of the Honorable Chief Justice.
I sincerely apologize. My junior was there, but she couldn't mention. And
No mentioning now.
Your Lordship, I was only praying that
No
matter
mentioning.
could be taken up on 13th.
No mention.
Number 5, I appear for the respondent. Section number 5, I appear for the petitioner, my lord. It's a section 29A application at our instance, my lord. We are the claimant in the arbitral proceedings, my lord. My lord, this is the first extension that we require from your lordship, my lord. By consent of the parties have already extended by 6 months. My lord, the pleadings were completed on 4th of April 2024. And 12 months from that takes us to 3rd of April 2025. Then 6 months extension by consent of the parties took us to 2nd of October 2025. This application has been filed before my lord on 19th of September 2025. That is prior to the expiry of the mandate. I'm only praying, my lord, this is in the final stage, my lord, only the arguments are left, my lord. We have a claim, they have a counter claim bigger than us. Claimant has commenced the argument. Yes, we have commenced the argument.
Yes, your lordship.
Take down. This is an application filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996 for extending the time period for concluding the arbitral proceedings and publication of the award. What?
No. I'm just trying to understand how long.
Arbitral proceedings and publication of the awards. Full stop. This court-wide order dated 17/1/2023, appointed the sole arbitrator for adjudicating the dispute between the parties. Full stop. The parties extended the timeline for 6 months by mutual consent. The time period was extended mutually by mutual consent by 6 months. Full stop. The said timeline expired on 2/10/2025. It is stated by the party that the matter is at final argument stage. Full stop. This court has heard the arguments and examined the records. Full stop. The learned sole arbitrator has held 31 hearings and the matter is at the stage of final argument. Full stop. Upon consideration, this court is satisfied there has been no undue or unwarranted delay on the part of the learned sole arbitrator in conducting the proceedings. Full stop. Accordingly, उससे पहले एक लाइन लिख देना. Learned counsel for the respondent has no objection for the said timeline to be extended. Full stop. उसके बाद कर देना. Upon consideration, this court is satisfied that there has been no unwarranted delay or on the part of the learned sole arbitrator in conducting the proceeding. Full stop. Accordingly, the mandate of the arbitral sole arbitrator is extended for a further period of
4 months.
6 months.
6 months.
6 months.
Great. 6 months.
Final argument 6 months.
Final argument just commenced because it's a counter claim is also there. So I guess a
Like almost
little bit of
priced.
reasonable time would be required for the arbitrator also to prepare the award. 6 months.
6
Your
months
lordship
from
can.
today,
In effect, we have
learned
become the
sole
respondent.
arbitrator is requested to ensure that the arbitral proceeding is concluded and the award is published within the time extended by this court. Full stop. With this observation, the present petition is
Great.
disposed.
I was led by Mr. Chakraborty. He was appearing online.
I was there, Your Lordship. I was there, but my junior was doing properly, so I did not interfere.
All right.
Great.
Just take,
Deeply,
Great, my lord.
give his appearance.
deeply obliged, Your Lordship.
Great.
In 6, my lord, I appear for the petitioner. I'm appearing for the respondent, my lord. I'm objecting to this application, my lord.
My lord,
No.
I beg to appear on behalf of respondent number 4 and 5, my lord.
I'm for the
Respondent
respondent
number?
number 1.
Respondent number 4 and 5, my lord. And I have no objection if the prayers, my lord, are granted by this honorable court, my lord, in terms of the
Yeah,
application.
respondent one.
I have an objection, my lord. I want
Yes.
to file my affidavit to that effect, my lord. We have a serious allegation, my lord, as to the forgery of the signature of the respondent number 3 and 4, my lord.
Very
And apart from that, we have filed a section 16 application, which is required to be heard, my lord. My lord, may I make my submissions? I'm the
Yes.
petitioner, my lord. My lord, this is an arbitration relating to a partnership dispute. The petitioner is one of the partners. The respondent numbers 1, 2, 3 are the real contesting respondents whom my learned friend today appears. So, my lord took this matter up yesterday also. My lord, here the arbitral proceedings have been proceeding before an arbitrator appointed by this court. Section 11 filed, respondents were present, objection noted, allowed. Today we are in a section 29A application, and that too for the reason, my lord, because the learned arbitrator has time and again sought to proceed with the matter. The respondents have been completely lackadaisical with their approach, and the arbitrator, my lord, I had placed yesterday. If my lord kindly takes page 38 once,
Page.
page 38 if my lord takes once, this is the minutes of the learned arbitrator on 22nd May 2025. My lord, the conduct of the respondents has been abhorrent in this arbitration. That's noted by the learned arbitrator. So question of filing any affidavits in this matter. Rather, my learned friend is lucky that he has a right of audience. My lord, page 38, if my lord kindly takes. My lord will kindly see the arbitrator's observations at page 39. 39, my lord will kindly take the last paragraph. I place this page, my lord will perhaps recall. Last paragraph, if I may place at page 39. After considering the facts and circumstances of the case, it appears that from the beginning, the conduct of the respondents shows that they are not interested to proceed with the matter properly in accordance with the provisions of law, except trying to find out a ploy to get time. Hence, in my opinion, the matter should proceed ex parte after giving a notice from the next date. From the next date onwards, my lord, the learned arbitrator has taken pains to serve notice by registered post as well as email throughout. We have proceeded, we have filed our affidavit of evidence. My lord will kindly take page 41, affidavit of evidence filed. Now, this 29A application also perhaps would not have been necessary because 29A1 contemplates 1 year from date of completion of pleadings. Here, not all the respondents have filed a statement of defense. It can be argued that pleadings have not been completed for the time period to commence. But out of abundant caution, my lord, I have taken out this application so that there is no dispute later on, so that I have an order from your lordship saying that the arbitrator's mandate is valid. Now, today, the question of an affidavit, number one, is completely misconceived in a 29A application, first and foremost. Secondly, my lord, will kindly note who is making this submission. This is my lord, with the deepest of respect, my lord, the arbitrator, my lord, is a retired justice, my lord. There's no question as to his proceeding or other procedural propriety. This is the noting of the learned arbitrator himself. Now, my lord will kindly take my pleadings. I won't go into anything further. My lord will kindly take para 9 and 10. I've stated the reasons on which I am seeking an extension of his mandate. This is not a proceeding that is adversarial at all against my learned friend today. Para 9 and 10, my lord will kindly consider. That is my explanation that is there. I have taken out this application out of abundant caution. My lord, may I say, my lord?
Just a minute.
Of course, of course, of course. Yes.
Well, that is my submission as to the section 16 and all of the points that my learned friends will make the appropriate prayer before the arbitrator. That's all I'm seeking, my lord. My lord, today, since we are at the state of evidence, I'm seeking a year's extension, my lord. I'm not seeking a mere 6 months. If my lord will kindly consider. Because we have been diligent. We have done everything in our powers to proceed with the arbitration as a claimant. It's the respondent numbers 1, 2, 3 who have been repeatedly. They've had 3 changes of their advocates, my lord. I can say that on instruction. I can produce the documents also. 3 sets of lawyers have come one after the other for whatever reason and sought to delay the proceeding. That has caused the arbitrator to pass that drastic order on 22nd May. Yes. They've also been asked to appear before the arbitrator. They've still refrained, despite notice, despite requests of the arbitrator himself.
Yes.
Milord, first of all, we are not challenging the propriety of the arbitrator, Milord. Milord, second of all, Milord, we have sent email to the arbitrator on the basis of the agreement, on the basis of which the arbitration was initiated, Milord. That is under challenge, Milord. We have lodged a FIR, Milord.
Very good.
And
Raise all
Milord,
this
Milord,
contention before the
the
arbitrator.
situation become alarming, Milord, when we challenge
The
these
situation is
things,
more
Milord. When
alarming
we take up
because-
the point, Milord, they fail and neglected deliberately, Milord, to produce the original deed of partnership, Milord, on the basis of which they initiated arbitration, Milord.
Very good.
Milord,
Go
we
and
will argue
raise-
before the arbitrator.
Go and raise all this before the arbitrator. Nothing
Milord.
in 29A.
Yes, Milord, we will,
Why
Milord.
do you want to file?
But
You
Milord,
want
we want to bring on record
Nothing on record.
the FIR, Milord, and the
Look at your
complaint.
conduct.
Milord, it is not our Milord, after filing of
I
the
don't need to
affidavit
hear
of
you also.
admission and denial, Milord, they have filed section 17 application to delay the
Go
proceeding.
do whatever you have to do before the arbitrator. If your consent is here, it's okay. Even if it's not here, I don't care. Take down.
Let my consent not be recorded, Milord.
No, I will record your conduct. Forget the consent.
It is all
The-
on record, Milord. What I am not.
You have made your submission?
Yes, I meant it.
The petitioner, the present application has been filed by the petitioner under section 29A of the Arbitration and Concession Act 1996, seeking extension of time for conclusion of the arbitral proceedings and for publication of the award. Full stop. This court, by order dated 31/12/2023, appointed the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned counsel for the petitioner submits that the respond number 1 and 3.
1, 2, 3.
1, 2, 3. 1, 2, and 3 subsequently stopped appearing before the arbitral tribunal, and accordingly, while order dated, what is the date of this order?
22nd May 2025.
22nd May 2025. They were proceeded ex parte. Full stop. The respondent filed statement of defense on 22/7/2022. Full stop. Hence, the said date can be treated as the date of completion of the pleading. Full stop. The mandate of the arbitral tribunal expired on 2021, right?
22nd July
22nd
2025.
The petitioner has therefore filed the present application seeking the extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the petitioner has drawn the attention of this court to the conduct of the respondent number 1, 2, and 3, where they had stopped appearing in the court, and it has also been recorded in the order dated 22nd of May 2025 that the conduct of the respondent number 1, 2, 3 seems that they are not interested to proceed with the arbitration proceedings, and thus the learned sole arbitrator had proceeded ex parte against the respondents. Only 1, 2, 3, and 4 and 5 are
4 and 5, my lord, are
One have filed
consenting. 4 and 5 have consented, my lord. They were appearing virtually.
Yes.
They are
Only
consenting.
one have
My
filed.
lord, yes, my lord. We have no objection, my lord.
learned counsel for the respond number 1, 2, 3 states that they have
Only respond number
objection-
1, Milord.
They have
I'm only respond number 1, Milord. I'm representing.
only for 1.
Yes,
We
Milord.
served all the rest, my lord.
Learned
Affiliate
counsel
service is
respondent
there.
number 1 states that he has an objection to the extension of the timeline of the arbitral tribunal. He states that the contract on which the arbitration proceedings, the foundation of the arbitration proceeding, the contract is itself stated to be false and fabricated.
Yes.
Full stop.
Signature have been false, my lord.
The
We have also lodged FIR, my lord.
full stop. Though this court is of the prima facie opinion that the respondent has not participated in the arbitral tribunal and all these contentions
We,
could have been raised before the tribunal,
we have raised it under section 16, my lord.
and to make this a ground for non-extension of for denying the extension of the timeline of the arbitral tribunal will be against the mandate of the tribunal. Full stop. The conduct of the respondent itself is not inspiring to take this contention into account. Full stop. Learned counsel for the respondent number 4 and 5 states that they have no objection to the present petition and consent to the extension of the time period of the arbitral tribunal. Full stop. Upon consideration, this court is satisfied that there has been no undue delay or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended further for a period of
1 year I'd be praying, my lord. This is at the stage of evidence, and I don't know what the respondents will do.
8
my lord.
months.
Fine.
For a
Whatever.
period of 8 months from today. Full stop. The learned sole arbitrator is requested to ensure that the arbitral proceedings are concluded and that the award is published within the time period. Full stop. With the above observation,
Only one indulgence, my lord. My lord, before proceeding to evidence, my lord, may my application under 16 be decided, my lord.
Go and make this submission before the learned arbitrator.
Your Lordship, I am appearing for the claimant, the petitioner herein. We are also applying for the extension of time. Your Lordship, there has been 4 extension and all the pleadings and arguments are complete. We are just awaiting for the award to be passed. Last such meeting.
Argument has been done.
Yes, Your Lordship. We are just awaiting for the award to be passed. So, Your Lordship may just extend it for 6 months.
Why 6 months for passing the award? What are you saying?
Lordship, at page 25 is the last such minutes which has taken place. And at 27 is the last extension, Your Lordships.
Check down. The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and for publication of the award. Full stop. This court-wide order dated 5/1/2023, appointed a learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on. When were the pleadings completed?
Your Lordship, on 10th September, His Lordship has, the learned arbitrator has recorded that the pleadings are completed and matter is reserved for pronouncement of award at page 26, middle of the page 26.
The pleadings have been completed and the matter has been argued. The learned arbitrator had reserved the matter for pronouncement of award on 10th of September 2025. Full stop. The present application has been filed seeking extension of the mandate of the arbitral tribunal for pronouncement of the award. Full stop. Learned counsel for the respondent states that he has no objection to the present application. Full stop. Upon perusal of the record, it is noted that the learned sole arbitrator has completed the proceedings and the award is reserved for publication.
Yes, sir.
Full stop. Upon consideration, this court is satisfied that there is no undue delay or unwarranted delay, or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. Accordingly, the mandate of the learned sole arbitrator is hereby extended further for a period of 3 months from today. Full stop. The learned sole arbitrator is requested to ensure that the arbitral award is published within the extended time period. With the aforesaid observation, the present petition stands disposed.
Obliged.
All right, I am appearing for the petitioner in item number 8. This is also an application under section 29A. The learned arbitrator was appointed by this honorable court under section 11 on 11th July 2023. The pleadings were completed on 5th April 2024, but there was an application under section 16 by the respondents which had to be disposed of. And both parties by consent extended the time for 6 months, which expired on 6th October 2025. We are now at the stage of examination in chief of the claimant's witness. I'm praying for an extension of at least 1 year to complete the arbitration.
Lordship, appear for the respondent. Lordship, I do not object.
The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. Full stop. This court-wide order dated appointment is 11/7, right?
11th July, yes, my lord, 2023.
11/7/2023 appointed the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months till extension was
6th October 2025.
6th October 2025. Full stop. Since the mandate of the arbitral tribunal 6th October it has already expired, the petitioner has preferred the present application seeking extension of the seeking extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the petitioner further states that the proceedings are at the stage of
Evidence.
My lord, examination in chief of the claimant's witness. Just, my lord, the evidence has started.
Full stop. Learned counsel for the respondent states that he has no objection to the extension of the time period of the tribunal. Full stop. To the present application, no objection to the present application. Full stop. Upon consideration, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended further for a period of 1 year.
My lord, 1 year, yes.
For a period of 1 year from today. Full stop. The learned arbitrator is requested to ensure that the arbitral proceedings are concluded and the award is published within the time extended by this court. Full stop. With the aforesaid observation, the present application stands disclosed.
Deeply obliged, my lord.
By application on 29A, but Lordship will take page 154. It's an order by which mandate was extended till 6th November 2025. Arguments have been concluded. It's pending for publishing the award.
Only for publication?
Only for publishing the award. 3 arbitrators appointed by mutual.
Who's there on the respondent?
I've served. I've served.
Service?
I've served. The affidavit of service has been filed, my lord, I'm told. Copy to that. But I have a copy with me. There is an endorsement on behalf of the.
It's all on the record. When did you serve?
Well, it was received on 3rd November 2025. There's an endorsement by the advocate for the respondent. May I hand up a copy? Endorsement on the back sheet of the affidavit of service.
The present application, take down. The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that with the mutual consent of the parties, the arbitral tribunal was constituted on. When was the?
But it was constituted when the presiding arbitrator accepted the appointment on 2nd January 2023.
2nd January 2020.
23.
Full stop. When did you file the statement of claim?
The pleadings were completed. There is a counterclaim. So the rejoinder was completed on 16th June 2023.
Completed before the tribunal on 16th of June
2023.
2023. Full stop. The final arguments. The final arguments.
The final arguments have been completed in August 2025. I've pleaded. I'll give the date.
Where is that? The final arguments have been concluded on.
Paragraph 15, 11th August 2025.
11th August 2025. Full stop. Learned counsel for the petitioner states that the award, he's seeking an extension for only publication of the award. The proceedings have already been concluded before the learned sole arbitrator.
But 3 arbitrators, arbitral tribunal.
Learned sole arbitral tribunal. Oh, sorry. Before the learned arbitral tribunal. Sole arbitrator, but before the learned arbitral tribunal. Full stop. Upon consideration, full stop. Upon consideration, comma, it is upon consideration, it is noted that there has been no undue or unwarranted delay on part of the arbitral tribunal. Full stop. The matter has already been heard and the matter is listed for publication of the award. Full stop. At this stage, none appears for the respondent, though despite service, none appears for the respondent. Full stop. In view of the submission of the learned counsel for the petitioner, this court is inclined to extend the time period of the arbitral tribunal further by.
I'm told, Malad, it would require 3 months more.
Further by 3 months for publication of the award. It is requested that the learned arbitral tribunal shall publish the award within the extended time period. With the above direction, the present application is
grateful. 3 months from the date of expiry or date of this order?
Today. 3 months from today.
Grateful. Grateful.
This matter I appear for the petitioner, Malad. This is an application filed under section 29, Malad. The honorable arbitrator was appointed by this honorable court on January 4th, 2024. The first sitting was held on February 26, 2024.
When was he appointed?
On January 4th, 2024, my lord, appearing at page 17 of this application.
Yes.
And by consent of the parties, the mandate was extended for the period of 6 months on July 31st, 2025. The minutes is appearing at page number 21, my lord. The mandate of the Honorable Arbitrator expired on 9th of November 2025, and this application was filed on 7th of November 2025, my lord, which is before the expiry of his mandate.
Now it doesn't really matter.
My lord.
Take down.
Only one more thing, my lord. My lord, I'm humbly praying, my lord, if the extension can be for a year, my lord, because in one of the matters, they are the claimant before the same arbitrator. And dispute arising out of the same agreement, my lord, we had also filed an application. The Honorable Court was pleased to appoint him. That order was passed on 26 June 2025, my lord. In that matter, we have filed a statement of claim. My learned friend is supposed to file his statement of defense, my lord. And by consent of parties, my lord, because the issues are common, my lord, in both the matters, my lord, the argument is to take place together, my lord. So I was humbly praying, my lord, if the time limit could be extended by 1 year, my lord, because both matters are being taken up together, my lord.
He has not asked for it.
My lord.
Well, that
No,
is
in
the
that
subject matter of a different issue, but we are only seeking for 1 year's extension, my lord.
You're seeking 1 year extension.
My lord, because both the matters, my lord, are being taken up together, my lord. In that, the time limit has not expired, my lord.
All right. The same Kardana, the present application filed so and so. Full stop. Learned counsel for the petitioner submits that this court-wide order dated 4/1, right? 4/1/2024, appointed the sole arbitrator, for adjudication of the dispute between the parties. Full stop. The parties, by mutual consent, extended the mandate of the arbitral tribunal by 6 months on 31/7/2025, and the said mandate is expiring on 9/11/2025. Has expired on 9/11/2025. Full stop. Learned counsel for the parties submit that the matter is at evidence stage.
My lord.
Evidence stage. Full stop. In view thereof, the petitioner prays for extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the respondent states that he has no objection to the present application. Full stop. The record reflects that there has been more than 38 hearings. 38 hearings, and and the arbitral tribunal is in the process of recording of the evidence.
It is at the completion stage, my lord.
Not completed. Recording of the evidence. Full stop. Upon considering the submission that the materials on record, this court is satisfied there has been no undue or unwarranted delay on part of the learned sole arbitrator. Full stop. Full stop. In conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended further for a period of 1 year from today. Full stop. The learned sole arbitrator is requested to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the aforesaid observation, the present application is disposed of.
Great.
But I apologize for intervening. But in item number 9, I prayed for 3 months, but it would require 6 months. I was instructed 6 months, but I said 3 months. The arbitrators would require.
Just for publication of the.
Yes, but there are 3 arbitrators. The arbitrators are in some difficulty till March. That has been communicated to us. If it could be for 6 months.
All right, give it 6 months.
I'm so grateful.
Item 9.
Great.
Item number 11, my lord, I'm for the petitioner, my lord. My lord, our counsel was unable to appear, my lord, today due to an unfortunate incident which took place yesterday, my lord. My lord, that's why, my lord, I'm paying for 2 weeks adjournment, my lord.
Let an unaffirmed copy be served upon us. We have been serviced with an unaffirmed copy. We do not know the veracity of the contents. Kindly pass a direction that they should give us an affirmed copy so that we also know what the petition
Give a
contains.
copy. Why you have not given a copy?
My lord.
Kindly gives the direction. I am appearing for the respondent. I am the
My lord.
The petition in the present application, the petition in the present petition. The petitioner has filed the present petition under Section 34 of the Arbitration Conciliation Act, challenging the arbitral award dated 23/5/2025, passed by the learned sole arbitrator. Full stop. The petitioner is directed to supply a copy of the 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 present petition upon the respondent. Full stop. Learned counsel for the respondent seeks and is granted. How much time? You file your affidavit.
4 weeks, Your Lordship.
Affidavit in opposition within 4 weeks. Reply to the same within 2 weeks. List in the monthly list of monthly list में डाल दो.
Preliminary, I have not taken any preliminary issues as of now because I have not been given the chance to.
That's why I'm giving you time to file your affidavit in opposition. Take what? Monthly list of January.
Grateful.
I'm for the petitioner, my lord.
The respondents, my lord, I'm praying for filing my opposition, my lord.
My lord, in this matter, my lord, there is a slight mistake, my lord, for which I'm tendering my unconditional apology. My lord, in Annexure A, my lord, one letter that has to be annexed, but it has been pleaded, that is missing. That is the forwarding letter. There is only one annexure, that is their execution application. It was sent, we received it through a forwarding letter. That letter was not annexed, though it was pleaded. But I'm seeking 7 days time to file a supplementary affidavit. Pleading is there, even in the annexure also it is mentioned.
Direction of supplement there. I want to file opposition in this application. I give at least 4 weeks time to file my opposition. Because in this matter, the execution application has already been filed. That is pending. They have
filed our affidavit of
section 34, but I will
satisfy my lord regarding that.
I will take out the point in my opposition, madam.
But file their opposition.
Yes, definitely.
Take down.
Leave be granted for the supplementary. That is not good.
The petition represent the present petition has been filed by the petition under section 34 of the Arbitration Conciliation Act 1996, seeking to challenge the arbitral award dated 24/2/2023, passed by the learned sole arbitrator. Full stop. Learned counsel for the petitioner submits that the petitioner has availed a loan facility from the respondent, but subsequently defaulted in repayment. Full stop. Thereafter, the petitioner was arrested by the police authority in execution petition. In the police authority in execution petition, EC case number 350 of 2023. Full stop. EC case number and was produced before the court on 18/7/2025. Full stop. Upon giving undertaking to appear before the court on the next date of hearing and to file his affidavit of asset, the petitioner was released. Full stop. It is further submitted that upon inquiry, the petitioner came to know that this has been appointed unilaterally.
Unilaterally, my lord.
The petitioner had appointed the sole arbitrator unilaterally.
I'm opposing that. Even my lord, I will file my opposition in that.
Unilaterally for adjudication of the alleged dispute between the parties, and the learned sole arbitrator has passed the ex parte award dated 24/2/2023. Full stop. The petitioner contends that he had no knowledge of the arbitral proceedings and that no notice was ever served upon him. Full stop. And what do you want to file?
We want to file a supplementary affidavit, my lord.
Learned counsel for the petitioner states that he wishes to file a supplementary affidavit to bring on record.
My lord, a letter dated 19th June 2025.
A letter dated 19th of June 2025.
That is only.
Showcasing what?
My lord, that is a forwarding letter through which the respondent herein forwarded the execution application to my advocate on record.
Showcasing the forwarding of the execution application to the petitioner. Full stop. Where's the impugned this thing? Award, my lord.
It starts from page 52. Lord, there are 2 points. One is that section 21 was never served. Secondly,
that even if section 21 was served, since there is a unilateral appointment, the next step after section 21 would be normally to file a section 11. That was skipped, and the respondents herein, they themselves appointed a third party, saying that that person is a neutral person who can appoint arbitrator.
In this matter, there is arbitration agreement. The both parties have agreed that the matter has to refer to somebody that will appoint an arbitrator. That procedure has been applied here. We have referred the matter to third party. He has appointed another person.
Learned
Not a
counsel for the
unilateral
respondent refutes the said contentions and seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any. Is there a need to file reply to that also?
I don't think, madam. But we have to place the
Reply
record,
to
my
the
lord,
same
on
if
the
any 2
service
weeks
of the award and the other things.
List of 2 weeks. List in the monthly list of January.
Good.
Supplementary affidavit to file within how much time for supplementary affidavit?
1 week.
1 week.
Grateful.
This section 34 by the state, though filed within time, but there is a prayer for condonation because there's some confusion with regard to the date of the award and the service of the award. I have documents to show that I have got it on 26th of June, and I filed this on 26th of September. So, that's within 3 months. But
Where's the objection?
I don't think there's any.
We are moving the section 34 today.
It's appearing for the first time.
Appearing for the first time. In any event, it is within 120 days.
Yes.
So, Lordship will
formally not condone the delay and give affidavit direction.
grant directions
All
for
right,
filing of affidavit.
The petitioner has filed the present petition under section 34 of the Arbitration and Conciliation Act 1996, challenging the arbitral award dated 23/6/2025 passed by the learned sole arbitrator in full stop. Learned counsel for the respondent seeks and is granted. How much time?
3 weeks, Lordship.
4 weeks time to file affidavit in opposition. Reply, if any, within 2 weeks thereafter. List in the monthly list of January.
Very good.
January 2010 and supplement award dated.
So there is a direction to file the affidavit in reply to their opposition, Lordship.
My lord, I appear for a section 36, section 34 application, which, my lord, there is a stay in view of the section 36 application bill filed by us. And we have, my lord, secured the entire amount of 214
the execution
crores.
can go out of that. It's not execution, is state because they have secured the entire amount and we have withdrawn it by furnishing bank guarantee. But
So,
34
my lord, any day, Lordship fixes the section 34 application, my lord, to be heard out between the
it was
parties.
fixed today, in their presence. Management is not there.
I understand, my lord. I had some difficulty today. I apologize for that, my lord.
Yes, it is fixed.
It is fixed today, sir.
Yes. At 2 p.m, my lord. Little difficulty I have today, my lord. Any day, Lordship keeps it tomorrow also. I can do it, my lord.
Yes, Mr. Sinha.
As convenient to Lordship. Section 34 will take little time, Your Lordship.
Affidavits are complete, my lord. Any day, Lordship keeps it.
अच्छा 15 है कल ले सकते हैं कितने मैटर है
Lordship, I fixed a few section 34 of mine yesterday. That will only take 5-6 minutes time, my lord. Lordship can keep this also, man.
All right. At the request of the party, let this matter be listed tomorrow.
Tomorrow.
Grateful. Great.
Execution, Mr. Sinha, is not.
Execution may be directed to go to the list because that's state. So that should go to the list. That can't appear. Your Lordship may pass a separate order in execution, but I can hand up the order which stays the Joshi. We order to the award test. So there was a direction for EC to appear along with AP, but not. I think since the award is state, not this can be. There is a direction for the EC to appear along with the AP. Not. There is a direction. Not strictly speaking, nothing remains in the EC because we have withdrawn the amount upon furnishing bank guarantees. But really, EC can be disposed of with liberty to file a fresh note in accordance.
This can be disposed of.
Yes, not EC because we have withdrawn the money upon furnishing bank guarantee. So, not EC can be disposed of, right? With liberty to file in future in accord as the situation may.
Or either your lordship may kindly keep it out of list, make it out of list so that
It's his.
it's their EC. Lordship.
But it can be
Your lordship can be disposed.
The EC, the execution petition is disposed of in view of the fact that the award has already been stayed.
Yes, but state not upon securing
the
and we have withdrawn it upon furnishing bank guarantee.
The said amount, and the petitioner has already withdrawn
the deposited amount but upon furnishing bank guarantee.
Deposited amount about furnishing of the bank guarantee. Full stop. In view of the same, the EC stands disposed of
with liberty to apply a fresh.
You are the petitioner.
I'm the petitioner.
With liberty to the petitioner to
apply a fresh if the question so arises
at the requisite stage.
I'm grateful to you.
At the appropriate stage.
I'm grateful to you.
With the above direction, the petition is disposed of.
EC.com along with the connected GM their connected G is also
along with the applications.
I'm grateful to you.
For the respondent,
Milord, I appear for the petitioner.
Yes. This is Section 9 application, Milord. We have served our affidavit in opposition, Milord. May I file the copy in court today?
What steps have you taken after Section 9?
Milord, we have filed our Section 11 application, which is pending before the concerned bench.
This will keep pending.
Milord, Lordship, in the meantime, Lordship, we can keep Milord, the Section 11 application. Lordship will kindly give me a moment. But there's also a contempt from the Section 9, which is also pending.
And I'm not concerned about the contempt.
Lordship.
And I'm making it very clear, if you think that you can keep these 9 pending, I will not.
My lord, we don't want to. My lord, we want to finish off our 11. My lord, may I just clarify what has happened previously? My lord, we filed our Section 11 and the Honorable Bench, hearing this matter, was pleased to take up the Section 11, Section 9 and contempt together so that the matter can be disposed of and the arbitration can commence. We had made our suggestion. That was not accepted by the respondent. They gave their nominee arbitrator, which was not agreed. Therefore, the Section 11. We were expecting the matter to get disposed of, the Section 11.
Disposed of, sir. I don't have Section 11.
For the Section 11. So, all as far as the Section 9 is concerned.
That worked out in the earlier bench, not in this bench.
Malad, only as far as the Section 9 is concerned, my only prayer would be, Lordship, to grant us, we require only a week's time to file our affidavit in reply. Well, that time may be given.
Let this Section 9s keep pending in this one.
Malad, as far as kindly allow us to finish our.
You file your Section 11.
Malad, 18 September.
18 September. What
Lordship.
are you doing since then?
Malad, after that, Lordship, the Section 11 application has been taken up multiple times, but then it was being
taken up once.
I think it's been taken up along with the Section 9 and the contempt.
How can it be taken up? That
may I clarify, Milord? All 3 matters were taken up together.
Yes.
Milord, there was an attempt made to get the Section 11 disposed of and heard of along with the Section 9. But my lord, there was a question involved in the section 11 for which we sought time to file affidavit. Our affidavit has been filed. That matter is pending before another court. Insofar as the section 9 is concerned, we had served them our copy of the affidavit in opposition. The last order that was passed was on 24th of September 2025. My lord, they were supposed to file the reply and have the matter heard. It was fixed today, my lord. They are praying for time, my lord. I leave it up to your lordships, my lord.
My lord, because the affidavit in opposition was filed after seeking 4 extensions. We wanted to proceed with the section 11. Time was taken by the respondent to file their affidavit in opposition. They raised certain issues of maintainability, which is why they sought time. Otherwise, we were very happy to have the section 11 disposed of on the very first day.
They have taken 4 dates. You want to take 6?
My lord, we don't want to take. My lord, it's almost ready. That's why I was praying for only a week's time to file our affidavit in reply. We'll serve it in advance before that as well.
Why should I keep this section 9 pending?
My lord, there are.
Your reply.
My lord, because there are certain counter allegations which will have a bearing in the on the matter. Lordship, my only prayer is Lordship kindly permits us to give our response. Lordship hears it for 5 minutes thereafter. Lordship is not.
Lock, stock, barrel, go before the arbitrator.
My lord, we want to go before the arbitrator, but Lordship kindly will permit us to put in our reply at least. Thereafter, Lordship dispose it off.
Why should I keep these?
My lord, kindly allow us to finish our pleadings at least. My lord, otherwise it's going to, because that's going to be used. That will be used against us subsequently, because in the
go before the
my lord,
arbitrator. The arbitrator appointed.
My lord, the arbitrator, my lord, we are proceeding with that. Kindly permit us to put in our reply, and thereafter next week Lordship disposes it off. We don't have any problem, Lordship. We'll proceed. We are expediting the section 11. We want the arbitration to start as soon as possible, because despite enjoying an order of injunction that is being violated, we need to commence the arbitration in order to protect our rights. It's in our interest to start the arbitration, because this interim order
is still when?
till 31st December, but it's been flouted, almost rendered infructuous. Which is why we want to go before the arbitrator as soon as possible. But my only prayer is kindly permit us to put in a reply at least, because several new counter allegations have been made in the affidavit in opposition.
How will the reply help you?
Lordship, it will be, we want at least our stand in respect of the section 9 to be there on record, because an allegation has been made in the section 11 opposition as to contrary stands being taken by us, which is completely misconceived. We at least want our stand to be on record. Thereafter, Lordship kindly disposes it off. We'll expedite the section 11. We are already expediting it. We'll finish the matter, because it's in our interest to go before the arbitration. In fact, that is the only relief left now, because the section 9 court has not proved fruitful for my client, because that order has been violated, which is why we had to file a contempt. Now, Lordship, it was suggested by the court previously hearing that I'll take up all the matters together and send everything to arbitration. We were agreeable with that. Certain issues regarding maintainability have been taken, which is why we had to file all these replies. If that had not been the case, Lordship, perhaps I would not even made this prayer of filing a reply. We could have simply, Lordship would have disposed of the section 9. But only because of these issues being raised, kindly permit us to put in our reply by next week. Thereafter, Lordship disposes of the matter. But let us at least stand be on record. Well, that is my only prayer.
1 week.
1 week. Grateful. Grateful.
Learned counsel for the petitioner seeks and is granted 1 week time to file his reply. List after 1.
After 1. Milaj, will it be your lordship's pleasure to fix it the week thereafter? Milaj, I'm led by a senior, Milaj, Mr. S.N. Mukherjee. He's not available. I'm told he's not disposed to appear in that particular week. If your lordships are fixing the matter, that is.
Yes, I'm fixing the matter. Yes, after a week.
Milaj, may I request in the week commencing 24th, Milaj, if it's convenient to this court, Milaj.
But I will not object on that ground, Lordship.
No, not at all. Why should I unnecessarily keep the matters pending?
No, Milaj, which is why, Milaj, I leave it entirely to your lordships, but I'm just making this request.
I'm not inclined to entertain this application at all.
I understand that, Milaj, but
be it you, be it anybody, the outcome will be the same.
I appreciate that, Milaj. I'm just making this request led by a senior, but whatever your lordships.
24th November.
Grateful, my lord.
After the opposition is kept on record.
Milord, we've filed our opposition today in court.
In the meantime,
Malad, we will expedite it, because it's in our interest to have it before the arbitrator. It's in our interest. Grateful.
My lord, I beg to appear on the petition in this matter, my lord. This is my application under section 14 of the Arbitration and Conciliation Act. Now, my lord, due to some difficulties, my lord, at the outset, my lord, I would be humbly seeking for a day's accommodation. My lord,
My lord, I will
if
not
your
oppose
lordship
that. My lord, I
kindly,
only have one
my lordship,
submission to make. My lord, this is an application under section 14, my lord, for terminating the mandate of the arbitrator. My lord, on the ground of unilateral appointment, etc. My lord, I do not, my
right,
lord,
right.
go into the, my lord, the merits of the matter. My lord, I saw, my lord, the disputes, my lord, are, my lord, it's a very, my lord, very small contract. My lord, the outstanding, my lord, total outstanding is about 12 lakhs. As of today, just about 2,35,000. So, my lord, if my land from my lord, instead of my lord, again getting an arbitrator appointed and my lord, again starting fresh arbitration, my lord, for this amount, my lord, if they could not clear the areas and what some amount
Absolutely, absolutely.
rescheduled, my lord, and we don't need to really litigate any further on this. Not if my friend could take instructions and come back on Monday.
Absolutely, absolutely. I'll come back next week, your lordship,
I'm grateful.
regarding this.
We really don't want to not go.
Learned counsel petitioner states that he is in some personal difficulty and prays for an adjournment. Let this matter be listed after 2 weeks.
Very well. After 2 weeks.
After 2 weeks.
So grateful, man.
I'm grateful to you.
Daily list, no? Sorry, monthly. नहीं 77 से शुरू होगा ना
Item number 77. Item number 77, my lord. London Senior Counsel Mr. Nilanjan Bhattacharya is appearing for the respondent, my lord. Due to his health issue, my lord, he is not available today, my lord. I am praying for only not this week, my lord.
Why should I even monthly list January? All those people are not interested. Monthly list January. Get it out of the list. Huh. You are appearing for?
Respondent, my lord.
Who's for the petitioner? None for the petitioner. Let this matter be listed in the monthly list. Why should I even dismiss in default? Karna shuru karunga. Give it to me. I'll dismiss in default. Why these petitioners are not appearing? It's been the second week for me. I'm not going to listen to this nobody turning up. None for the petitioner, dismiss the default.
By 78, my lord, I am for the petitioner, my lord.
I am for the, my lord.
There are
What-
two
what is the
applications.
respondent?
One is
I appear for one of the respondent.
my lord,
One
but
of the,
on the
I
ground.
was one of the claimant before one of the arbitral tribunal. My lord, this is section 34 appearing for the first time. My lord, if your lordship kindly permits me, my lord, kindly allows me to use an affidavit. My lord, to this application, my lord, we can come back before your lordship.
First time? This is the first time it's coming up?
First time, my lord. And
Yes.
my lord, my application under section 36 is also appearing, my lord. I have filed that for exemption of the depositing of the amount, my lord, on the ground of fraud.
My lord, I would, my lord, take serious exception to this. My lord, kindly allows me to also, my lord, file a my lord, opposition to this. It has been pending since. Kindly allows me to use an opposition to this also.
So these item 78, 79.
Yes.
78 is 34.
34, my lord.
79 is my lord 36 too.
36.
Yes, my lord. May I file my affidavit of service, my lord?
34 में affidavit of service taken. 34 in
34 and 36
combined.
In both matter, I have
All right,
stopped
take
them.
on first. Take 78. There is a petition filed under section 34 of the Arbitration and Conciliation Act, challenging the award dated.
Award dated
My lord. 17th of May,
17th of
2024.
May,
2024.
2025.
24, my
2024. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List in the monthly list of January. Item 79. There is a petition filed under Section 36 of the Arbitration and Conciliation Act. Give me the petition. Seeking a direction to stay the award without deposit of any security on the ground of fraud. Learned counsel for the respondent refutes the ground of the contentions made by the learned counsel for the petitioner. He seeks and is granted 4 weeks time to file his reply. List on reply, exception 2 weeks. List same dates. Monthly list of Jan.
I'm grateful.
Your Lordship, I'm appearing for the petitioner in this matter. Your Lordship, I'm seeking Your Lordship's kind liberty and time to file our Vakalatnama. This is a newly interested matter to us.
There's a APCOM 947.
Yes, Your Lordship. APCOM 947 was a stay application, Your Lordship. We have obtained a stay in there, and the matter was disposed of by Your Lordship's predecessor, and we have already furnished a performance bank guarantee to the tune of 8 crores and 95 lakhs and all.
Learned counsel for the petitioner states that he has been newly engaged in the present matter. He seeks and is given liberty to file his Vakalatnama. Let this matter be listed in the monthly list of January.
Much obliged, Your Lordship.
None for the petitioner. Dismiss in default.
I am the petitioner in this matter. That this is an application for setting aside of an award. Happily, my lord, both the petitioner and the respondent both are asking for setting aside of the award. My claim had been rejected. Their counterclaim had been rejected. My lord, the expert witness who gave evidence, my lord, that was not produced before us. We did not have the opportunity of cross-examining. An award has been given.
Well, before Mr. Mitra can go further, Lordship kindly takes a look at the 18th February order passed by Justice Sarkar. 18th February this year. When the matter first was called, first day, this is really the first day, the matters 18th retain their position in the list. In the meantime, affidavits may be exchanged by the parties. The first is their application 34. I am told my affidavit is ready by client side Hyderabad. Give me 2 days time. I will file my opposition. And the second matter is my 34. It is their choice if they want to file any affidavit. That's not my lookout. But kindly give me 2 days time. I will
Yes,
take my
Mr. Mitra.
Then I suppose the আমাদের affidavit রয়েছে. We should also file an affidavit. We should also file an affidavit. Yes. Then, my lord, let us have the same order for both the parties. My lord, instead of 2 days, my lord, give us 2 weeks. 2 weeks. 2 সপ্তাহ লাগবে.
So the first petition is yours.
Yeah,
the second one.
My petition.
Take down. Mr. Jayantani Mitra, senior.
My learned friend will be filing his affidavit in 2 days, my lord.
And is granted for the
I'm not
time
so
of.
fast, my lord.
You'll file your affidavit, right?
I should be filed in their application.
That's correct. The first one is yours. The first
one is there.
First one is
then since I take advantage of that 2 weeks, both same direction.
Learned senior counsel, Mr. Obrujit Mitra, seeks and is granted for the time of 1 week.
But if they take 2 weeks, I will also take 2 weeks. That's the advantage. Since both will be heard together, might as well take
2 weeks. 2 weeks to file his affidavit on opposition. I don't think so there's any need for reply to this affidavit.
It's up to them. I would personally say I will bring on
reply
records.
to the same
Yes, I do not think, my lord, it is on the basis of the records of the arbitrator that we shall make our submissions.
Some of the correspondence between the parties, but matters of record.
But what is it? Generally, people don't file their replies, but counter and then again a reply to that.
Only counter is good enough.
I think counter is good enough.
Counter. In weeks time to file.
Somebody disclose some new document, we shall take leave.
Arbitrary record, arbitrated. 2 weeks time to file affidavit in opposition. Second violation. Same order. Mr. Jayanta Mitra seeks and is granted 2 weeks time to file his affidavit in opposition. Now this will go. When do you want it?
Whenever, Lordship, as per my lords, because
nobody's arguing 34.
Well, we are eager to argue this matter. This is an interesting matter for we are all both eager to argue.
Kindly did then fix the date.
Both
kindly did then fix the date, my lord. Then we shall both. Then Mr. Mitra will make his diary empty that day, and then he will make some time.
My diary is empty anyway.
No, don't say that. Trouble you all the time.
I was just
hearing. Lordship, kindly fix it. Then we shall.
Hearing Mr. Mitra in Delhi also, in that. You were there, AK Sen Memorial Lecture. So I had the opportunity of hearing you there.
Memorial Lecture. Well, your lordship heard that.
I was there.
I don't know, my lord, whether it was worthwhile, but then
no,
again,
it was. It was such insightful, and we heard so many anecdotes on Mr.
You
Sen.
would be having personal.
It was very.
Well, I was invited because I am one of the very few persons, my lord, alive who had a personal experience.
We gained a lot from all those insightful your personal experiences and your.
Well, I'm surprised your lordship had the time to.
Yes, I was there on Friday.
Well, I'm very grateful to your lordship.
I have also worked, but then his very end. Mr. Mitra must have worked with him.
No, not so
extensively.
No, not extensively, but I had the occasion to. He was a genius of a sort.
Absolutely,
absolute genius. Well, I have not come across any lawyer with that kind of a memory. Absolutely phenomenal. Well, as I told my lord in that lecture, I remember, my lord, that Gherao matter. He didn't have a piece of paper in his hand, and he argued the matter for 1.5 hours, quoting from, my lord, the chapter and verse quoted from various English judgments. Well, those which I've studied in
Phenomenal memory, I guess.
phenomenal memory.
But that I have not seen Mr. Sen's memory. But when you hear Justice Rohinton Nariman giving speeches, what
he's
on,
also
on World
Yes,
War, on
yes.
music, on
As a lawyer, I had the opportunity of briefing him, and incredible,
incredible memory. Absolutely. He has also, and he also, my lord. I had the occasion to, my lord, personally talking to him personally, sitting across the table in either, my lord, I won't tell your lordship where we sat together, but my lord, at places where, my lord, I had the occasion to, he was quoting from Shakespeare, my lord, the Tempest,
Oh, yes, yes.
Midsummer's Night's Dream.
a variety of subjects.
Absolutely. Phenomenal.
Mahabharat, he will go to Beethoven, he will go to Second World War. Any topic he can cover.
Really amazes me how these people remember so much.
Absolutely.
Maybe there were less distraction at that point of time.
So he came because he's a Parsi priest. He had to do that
memorize and
memorizing. So that's what he has. That's what he says.
True.
But I wonder whether too much of good memory is good or bad. Well, there are certain things you want to forget.
You can do that.
Well,
Selective memory.
Maybe request the records of the arbitral proceeding to be directed.
Yes,
to be
I
produced
think
to us.
that will be.
So you have not filed it?
No, my lord, that is, my lord, with the arbitrator. My lord, your lordship may direct the registrar to, my lord, collect the records from the arbitrator, or, my lord, direct the parties to approach the
He has
arbitrator.
kept. I don't know whether now there's no direction.
Whenever
if it's
there's
available
any
with him.
formal paperwork, I've generally seen here that you file the.
We have got all the records at par
File
are
it.
here. That's up to point. I have nothing.
Well, if your lordship, my lord, gives a direction, my lord, that, as the saying goes, Odikanto Nodashayo. Your lordship will be pleased to, my lord, give a direction so that, my lord, if it comes in addition, if you need them, my lord, your lordship can look into them. If you don't need them, it's all right. The registrar to, my lord, be directed to collect the records.
The registrar is directed to requisition the arbitral
At a date now.
records
At a date now.
before the
Give a
next
date.
before the next debate. Let this matter be listed. Shall we put it in the monthly list of January then?
It will take us some time, no doubt.
Yeah.
January, monthly list of January.
I would like to do it because it's all about accounts. So,
first week of December.
Whenever lordship says,
If it's all about accounts, then I don't want to do it.
But I'm told lordship has I've come to learn from here. Lordship has a good understanding of accounts. I heard from somewhere.
My learned friend, my
No,
lord,
not
Mr. Mitra has very good knowledge of accounts. I don't have.
No, he's
I know that. Yes.
I leave it to the housewives.
that I do fully.
That I think for peace everybody does.
I'm grateful to your lordship. বল না কবে একটা ডেট দাও না 8 December my lord 8 December
Any confusion in the order?
8 December কি বার পড়ছে
Monday
very well
2 p.m. করে 2 p.m. 2 p.m. করে দিন
First one, which is with pro, second one.
My lord, by consent my lord subject to your lordship's pleasure 8 December at 2 p.m.
8th December?
Yes, which is a Monday.
Or any day, lordship, any other day.
In the meantime, my lord, all these formalities will be completed.
Or any other day commencing to my lord. 8th, 9th, 10th, 11th, whichever.
9th December.
Very
good
well.
for 9th. We'll try to, let's see.
Lordship.
No, 9th December. Won't fix a time.
Section 34 application. Section 34 application, I appear for the respondent. My lord, I think there has been a bereavement in the family of the learned advocate appearing for the petitioner. So she had informed me that she will perhaps pray for time.
All right.
So, my lord, any short date?
None appears for the petitioner.
My lord, Aparna Banerjee is.
You're appearing. Proxy counsel so and so appears for the main arguing counsel and states that there has been a bereavement in the family of the.
My lord, kindly fix it after 24th.
There has been a bereavement in the family. Full stop. She prays for an adjournment.
24th.
Praying for
That this matter be listed on 25th of May.
order dated. My lord, one more thing, my lord. By Lordship's order of 19th March 2025, the award holder was given liberty to file a paper book, my lord, or a compilation of documents we will do. May I hand that up, my lord?
The informal paper book is taken on record. The informal paper book filed by the respondent is taken on record.
Most grateful.
Lord, may I seek for an indulgence, my lord, out of turn?
Sorry?
May I seek for an indulgence, my lord, for an out of turn, my lord? Item 77, my lord, I was held up in division bench. By the time it got called, my lord, and the matter I am being informed that it was been dismissed for default.
Item 77. Not today, Karto.
Not today, my lord. Grateful, my lord.
77. Not today.
May it please, Your Lordship. I appear for the responding in item 85.
My lord, I'm holding brief for Mr. Choyan Gupta, my senior. He's facing some difficulty in appearing. Kindly fix it not this week, my lord.
Argue? You argue?
I'm Mr. Choyan Gupta's junior.
You argue, madam. It's an opportunity. A senior is not here. You can argue. Start. Where's the brief?
Lordship, in
My
fact,
lord,
the
I'm-
pleadings are complete. Mr. Gupta is aware that I have traveled from. I'm so sorry.
Yes.
My lord, I'm holding brief for the matter.
Good, you're holding the brief. Where's the brief? Where's the brief? Where's the brief? Where's your brief? Where's the file? How can you appear in the court without a file? As a young lawyer, how can you appear in the court without a file, even if you have to take time? Even if you're seeking an adjournment, you should never appear without a brief.
Please, my lord.
This is very deliberate also, Your Lordship, because Mr.
Have it
Gupta.
tomorrow. Not
Lordship, actually, I have a small request. I have traveled from Delhi for this matter. Your Lordship can keep it on a date fix or
when
something.
do you want?
Subject to Your Lordship's convenience, Your Lordship can fix it at any time. I can come and argue, but not tomorrow, Your Lordship. I'm in a difficulty
Mr.
tomorrow.
Gupta?
Mr. Gupta is on his legs in a different court, my lord.
Pass it over.
I'm here for the whole day.
Pass it over.
I'm very
Pass it
grateful.
over.
Very grateful, Lordship. Very grateful.
Call him.
Great. 85 and
85, 86
both,
connected.
both. 85 is section 34.
And 86 is
Execution. 67.
Your Lordship, I'm appearing for the petitioner. My senior is engaged in some other court in NCLT, so I
You
would.
must have heard. Where's your brief?
Your Lordship, I have the brief with me.
Madam, why do you appear in the court without a brief, even if your senior is not there? What is this practice? What is there in the matter?
In other court.
Your Lordship, after 2 weeks, if you can fix any date.
I'm making it very clear. If the seniors are not there, you start the brief.
Well, it says,
Yes.
well, I appear for the respondent. It's a simple section 34. If Your Lordship keeps it any day this week, also we can do it, Marlo.
Who's the main counsel?
Yes, sir, Your Lordship.
Where's the senior?
My senior, Mr. Vivek Basu, is engaged in some other court.
So next time when your senior is not there, come with the brief. We'll hear you.
Okay.
Not today.
Grateful.
I'll come back. Which is your matter?
93 or 90.
I'll come.
Your Lordship is going very fast.
To say nobody's here. You want to finish off matters. But that can only happen when, you have cooperation from.
Thank you.
Full
93.
Has the other side come?
It has not come as yet, Your Lordship. In this matter, I can only point out, Your Lordship, the seat is in Bhubaneswar. This matter is just being kept here to
other
clock
side-
the board. Nothing else. The seat, the contract says the seat is in
madam.
Bhubaneswar.
My lord, kindly keep it not this week, my lord. My senior is
Very unfair, Your Lordship.
Why?
They are aware. I have come here to.
Why not this week? Call your senior.
my lord. Fix it any day the next
Your
week,
senior, madam. Call your senior. This is not going to happen. Call your senior.
my lord. Then
Call your senior.
kindly let them argue, and we'll give our reply the next
I
day.
can argue, Lordship. There's no problem. I can
The
argue.
respondent.
Sorry.
He's the respondent. It's your petition.
They are the petitioner. I am the respondent. There's a
Your
preliminary.
petition.
My lord, kindly if you fix it the next week, my lord.
Call your senior first.
That's the.
I'm also not briefed in this matter, but I'm being told they had taken an initial objection as to jurisdiction of the
Yes.
34th. So they may argue this. My senior is indisposed. He's still on legs, my lords. There's some
Not
difficulty.
indisposed. There's a
In the
difference
sense that he's
between
still
being
on legs, my
indisposed
lords. I beg your pardon, my lords. He's still kindly for. I would have requested any time next week.
You
but
call him here. I want to see his face. I want to see where he's arguing. Call him here. Call your senior. He's in the court. Call him.
he's in the court.
Call him.
There's a. The contract says the seat
Wait a
is
minute.
Bhubaneswar.
You call him.
They are aware. I have come on previous occasions also here.
So you.
Deliberately.
I'll pass it over. You call him. Call your senior.
My lord, I am for the petitioner.
Yes.
Affidavit of service. This is an application for setting aside the award, my lord. February 2025, we have served them. Let the press service may be directed to again. One is appearing, my lord. Award dated, my lord, 20th June 2024.
Award is which year?
Award of the 24 of the 2024, my lord. 26 June 2024. Rohit Kumar Rai, sole arbitrator. Arbitrator is Rohit Kumar Rai.
Write it down. Petitioner has filed the present petition under Section 34 of the Arbitration and Conciliation Act, 1996, challenging the award dated 28/6/2024, passed by the learned sole arbitrator. Full stop. Affidavit of service taken on record. None appears for the respondent. The respondents are directed to file the affidavit in opposition within a period of 4 weeks. Reply to the same within 2 weeks thereafter. A copy of this order shall be communicated to the learned counsel for the petitioner, undertakes to communicate the copy of this order to the respondent. Let this matter be listed the monthly list of January.
I am grateful to you.
A copy of this order shall be communicated by the petitioner to the respondent.
Mediterranean of the monthly list. I'm grateful.
Item 85
Why
and
you're not
86
here?
are two applications. One is possibly under section 36.
Wait a
The-
minute.
I'm
All
sorry.
kinds of your junior first said you're
My lord,
indisposed.
my lord, I will not be able to do the matter for only one reason. The next two appeals before the Honorable Division Bench are mine, where I'm the appellant.
That's all right.
And my lord,
That's a different thing altogether, sir.
yes.
First,
So my lord,
first you hear me out.
yes,
First you hear me out.
yes,
Your junior appears and states that you're indisposed. Are you indisposed?
yes, my lord. Today I will not be able to do that.
Are you indisposed? Are you not well?
No, I am.
Yeah.
Yes, I am here.
Yes. What is the difficulty?
But the next two matters before the Honorable Division Bench of Justice Boshak are my appeals.
Yes.
Now, those have to be done today, my lord. There's a sale issued in the second one, where because of today's appeal, two other courts are not proceeding, giving date till today.
What is your
So,
name? What is your name, counsel?
I'm sorry, my
What
lord.
is your name?
Chayan Gupta.
So Gupta.
Yes, ma'am.
Every matter is important.
Yes,
If you can't do it, ask your juniors to assist this court. I'm not concerned.
But could I make one humble submission subject to what falls from your lordship?
Yes.
But could they argue today? But could I come back next week any day, give my reply?
Why next week? Why not tomorrow?
But, tomorrow and tomorrow I'm there.
Tomorrow
But,
also you're busy.
but could if there is some difficult, I'll do the matter tomorrow. But I would request humbly if it could be done any day next week, subject to my lord and my learned friend's convenience. But today, my lord, and tomorrow there's some difficulty. Well, if your lordship kindly considers. If not, then kindly keeps it tomorrow, my lord. I shall.
Ask your office or your juniors to assist the court.
The problem is my junior is also not here. He is in Chennai for a fixed matter to do. My lord, so I am totally, my lord, my hands are
So many
tied. My lord.
matters, Mr. Gupta.
That is my whole difficulty. Otherwise, my lord, any date, your lordship fixes a time, date, I shall do the matter. Or otherwise, my lord, if it so commences to your lordship, he has come from Delhi all the way. But let him argue today. But I shall give my reply on the next day, any day. Monday, Tuesday, any day.
It's your petition.
It's my petition, but they have taken a point of jurisdiction. So they would argue first. I need to satisfy that. So my lord, I'm not standing in the way of them arguing or taking the point. But let them do today, my lord. Kindly excuses me, my lord, for today, my lord, and for this week. Monday, your lordship would keep it. I'll conclude my arguments. Because I have a very short point.
Preliminary issue, Lordship.
There's a preliminary issue.
The
That is
contract says the seat is at Bhubaneswar. Lordship, may kindly see page 32 of the paperwork. Page 32, clause 14.
All right. Take your juniors to take note.
yes. But could I just file the reply, my lord? Let him argue his points, my lord. I shall give my reply. My lord, whenever your lordship keeps the
Filing
matter.
a reply today.
I'm filing the reply today. To both my section 34 and section 36. Your lordship will kindly pardon me today, my lord. Kindly, my lord.
85 is 34, right?
Yes. Item 85, section 34, file, your lordship, page 32, clause 14. Your lordship may have it. Arbitration clause. This is the arbitration clause. Any dispute.
My lord, could I just take your lordship's level? Kindly move.
Page 32, your lordship, of this.
Page
32. Clause 14. This is the contract under which the arbitration has commenced.
Yes.
Any dispute, differences or disagreement between the parties arising under or in relation to this contract, including but not limited to any dispute, difference or disagreement as to the meaning of the terms of this contract, or any failure to agree on any matter required to be agreed upon under this contract shall, if possible, be resolved by negotiation and mutual agreement by the parties and within 30 days. Should no agreement be reached, then the dispute shall be finally settled by arbitration upon the request of either party hereto in accordance with the rules of conciliation and arbitration of the Indian Chamber of Commerce by 3 arbitrators in the English language and in accordance with the said rule. The result of all such arbitration shall be final and binding for the parties and for all purposes. The venue of arbitration shall be Bhubaneswar. This is the seat of the arbitration, Lordship. I'm citing a judgment. If I may just hand over a compilation, Lordship, this will also assist in the submissions, Lordship. of this the contract says the venue of arbitration shall be Bhubaneswar. Now this compilation, if your lordship will kindly see page number 70, para 61. This is Supreme Court's judgment, BGS SGS Soma versus NHPC Limited. Page 70, para 61. Your lordship has it? It will thus be seen that wherever there is an express designation of a venue and no designation of any alternative place as the seat, combined with supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitral proceedings. The contract doesn't provide for any other seat, your lordship. Now, it is their contention because in accordance with section 20, subsection 3 of the Arbitration Act, copy this. Compilation. Your lordship has section 20. Lordship, I am relying on section 3. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts, or the parties, or for inspection of documents, goods, or other property. Now, your lordship, it is their contention because during the arbitral proceedings, we had agreed that because one party is from Delhi and the other is from Calcutta, the parties had agreed that alternate hearings of the arbitral proceedings can alternatively happen in Calcutta and Delhi. Now, at para 4, at page 4 of their section 34 petition, they have tried to read it as that we have waived the exclusive jurisdiction clause of Bhubaneswar court, the seat being Bhubaneswar. My contention is this statement before the arbitral tribunal was in accordance with section 20 subsection 3 because the seat will remain intact and parties for their mutual convenience can have different venues because the parties, one party from being Delhi and one from being Bhubaneswar. It doesn't affect the alteration of the seat. Your lordship may kindly see their pleading at page 4, para 4. Because it doesn't have the effect of altering the seat. The seat will continue to be Bhubaneswar. The venue will keep because 20 subsection 3 provides for that. It is for the convenience of the parties. The tribunal can decide or the parties can mutually decide.
But you can waive it off, which probably you might have done it.
Sorry?
You can waive it off with the consent of the parties. This can be waived.
Can be waived off, but it was in accordance with 20 subsection 3. It doesn't say that the seat will stand altered because the venue can be n numbers for the convenience of the party in accordance with section 20 subsection 3. I will rely on a judgment also to that effect, your lordship. Your lordship, in this very same for a moment, your lordship may have what they plead in this regard. How I have waived it, page 4, para 4 of their section 34 petition. Parties by their mutual consent can definitely waive off the seat. Page 4, para 4, your lordship. Your lordship has it. The present arbitral reference is being. I'm reading from para 3, your lordship. May bear with me.
What is your name?
Sorry.
What's your name?
My name is Sarad, your lordship. Para 3 at page 4, your lordship.
Yes.
Further, the said agreements also contain the said arbitration shall be conducted and proceedings.
This is the present arbitral reference is being held at the Indian Chamber. Is this the one you're reading?
Yeah, para 3, your lordship. For a moment, have para 3 also.
Further, the said agreements.
Yes, further the said agreements also contain that the said arbitration shall be conducted and the proceedings shall be held in Cuttack. This is a typographical error because the seat is Bhubaneswar. They have said it Cuttack, but it is Bhubaneswar. Now, para 4, your lordship.
Yes.
The present arbitral reference is being held at the Indian Chamber of Commerce and at Delhi alternatively. The fact that the meeting shall be held alternatively in Kolkata and Delhi was by consent of the parties and is recorded in the minutes of meeting dated 11/12/2023 and 13 January 2023. A copy whereof is annexed and marked with letter B. It was also recorded in such meeting that the venue of arbitration would be Kolkata and Delhi alternatively at the choice of the parties. It is by virtue of such that the exclusive jurisdiction clause and or implementation thereof was mutually waived by the parties. This is directly contrary to the judgment of the Supreme Court, which I have placed as the second judgment in the compilation, Your Lordship. I'm relying on that judgment, Your Lordship. For a moment, have page 126 of this compilation. The judgment starts at page 126, Your Lordship. The relevant para 14 is at page 132 of this compilation. This judgment is Videocon Industries versus Union of India and another Supreme Court. The Lordship has para 14.
Yes.
Shri Nariman then argued that after having expressly consented to the shifting of the seat of arbitration from Kuala Lumpur to Amsterdam in the first instance and effectively taken part in the proceedings held at London till 31st March 2005, respondent number 1 is stopped from claiming that the seat of arbitration continues to be Kuala Lumpur. The learned senior counsel submitted that the learned single judge was not justified in rejecting the objection to the maintainability of the petitions filed by respondent number 1 in the Delhi High Court merely because the appellant had earlier filed OMP number so and so before the High Court. He submitted that the doctrine of waiver and acquiescence cannot be pressed into service for deciding the issue relating to jurisdiction of the Delhi High Court to entertain the petition under section 9 of the Act. Shri Nariman further submitted that if respondent number 1 felt aggrieved against the partial award, it could have filed petition under section 67 and 68 of the English Arbitration Act 1996. Para 15, Your Lordship. Shri Gopal Subramaniam, learned Solicitor General, submitted that as per the arbitration agreement, which is binding on all the parties to the contract, a conscious decision, Your Lordship has it? A conscious decision was taken by them at Kuala Lumpur will be the seat of any intended arbitration, Indian law as the law of contract and English law as the law of arbitration. And the mere fact that the arbitration was held outside Kuala Lumpur due to the outbreak of epidemic SARS, the venue of arbitration cannot be said to have been changed from Kuala Lumpur to London. The London Solicitor General emphasized that once Kuala Lumpur was decided as a venue of arbitration by written agreement, the same could not have been changed except by amending the written agreement as provided under Article 35.2 of the PSC. Now, Your Lordship may have para 20 is the finding. Your Lordship has para 20. We shall first consider the question whether Kuala Lumpur was the designated seat of or juridical seat of arbitration and the same had been shifted to London in terms of Article 34.12 of PSC entered into by 5 parties. The seat of arbitration was Kuala Lumpur, Malaysia. However, due to break of epidemic SARS, the arbitral tribunal decided to hold its meeting first at Amsterdam and then at London, and the parties did not object to this. In the proceeding held on 14/10/2003 and 15/10/2003 at London, the arbitral tribunal recorded the consent of the parties for shifting the juridical seat of arbitration to London. Whether this amounted to shifting of the physical or juridical seat of arbitration from Kuala Lumpur to London. Now, para 21, Your Lordship may have it. Though it may appear repetitive, we deem it necessary to mention as per the terms of the agreement, the seat of arbitration was Kuala Lumpur. If the parties wanted to amend Article 34.12, they could have done so only by a written instrument, which was required to be signed by all of them. Admittedly, neither was there any agreement between the parties to the PSC to shift the juridical seat of arbitration from Kuala Lumpur to London, nor was any instrument signed by them for amending Article 34.12. Now, Your Lordship, I pause here for a moment. The subject matter contract before Your Lordship. Yes. Now, Your Lordship, the subject matter contract at page 32, clause 18. This is the exact case in this contract also. If parties want to make any amendments to the written terms of the contract, there has to be a signed and written addendum to this. Just by merely saying, by me saying that in accordance with section 20, subsection 3, I have agreed for shift of the venue for convenience of the parties, there cannot be a change to the seat. Your Lordship, for a moment, have clause 18 of the contract at page 32 of the paper book.
Yes.
Clause 18, Your Lordship, has entire agreement. This agreement contains the entire agreement between the buyer and the seller with respect to the subject matter herein and supersedes all previous writings, understandings, negotiations, representations, or agreements with respect thereto, except where provided otherwise. This agreement shall only come into force after being signed by both the buyer and the seller. Now, Your Lordship, this portion. Any amendments to this agreement shall be in the form of an addendum to the agreement and shall come into force only after both the parties will have signed the addendum, whereafter it will form an integral part of the agreement. Where has this happened? For them to say, my act, which is in accordance with section 20, subsection 3, how have I waived waived off the seat of the arbitration? This is my first contention. Now, Your Lordship may also have of this very same judgment, para 96 at page 50 of the compilation.
Page 50.
Page 50, Your Lordship. Your Lordship has it?
Yes.
Definitions. Definition of court under Arbitration Act. Now, Your Lordship may see the section 2E defining court has been extracted. Now, the finding. We are of the opinion the term subject matter of arbitration cannot be confused with the subject matter of the suit. The term subject matter in section 2(1)(e) is confined to part 1. It has a reference and connection with the process of dispute resolution. Its purpose is to identify the courts having supervisory control over the arbitration process. Hence, it refers to a court which would essentially be a court of the seat of the arbitration process. My contention is the venue has been defined as Bhubaneswar. As per the Supreme Court judgment, that venue is the seat, and it has to be a seat of the principal court at Bhubaneswar. This court, in my humble submission to this honorable court, does not have jurisdiction just because they happen to be situated in Calcutta. This court cannot be vested with a section 34 power in this matter. Now, Your Lordship, my second argument. Now, Your Lordship, they have approached this court against an order by which the learned sole arbitrator has rejected their amendment. My submission to this honorable court is that the appropriate stage for challenging a rejection of the amendment is only when the final award is passed, not at this stage. I am supported by a judgment of Delhi High Court. I'll just cite the judgment to the honorable court. The Lordship may just have it. Parasite at page 193 of the compilation, Your Lordship. Your Lordship has it?
Yes.
Para 6 at page 193. I consider that, Your Lordship has it? I consider that dismissing of an application for amendment of the written statement whereby the petitioner was not allowed to include the counterclaim at a belated stage cannot be termed as an interim award so as to allow the challenging such order under section 34. The petitioner would be at liberty to assail the final award and can take all the grounds of challenge as available under law as and when final award is passed by the learned arbitral tribunal. The petitioner cannot be allowed to challenge dismissal of its application for amendment as an interim award. One of the purposes of enactment of Arbitration and Conciliation Act 1996 was to minimize the intervention of the courts during arbitral proceedings, and that is why Section 5 of the Act prohibits the courts from interfering in the arbitration proceedings. The judicial intervention during arbitral proceedings is not permissible unless it is specifically provided for. Now, Your Lordship, in continuation to this, Your Lordship may have one more judgment at page 192. This is Bombay High Court judgment, Punj Lloyd versus ONGC. The judgment starts at page 194, Your Lordship. Your Lordship, the relevant portion is at page 198, para 19. The same judgment of Container Corporation has been extracted and the Bombay High Court relies on this. Page 198, para 19, Your Lordship. The Delhi High Court, Your Lordship has it. The Delhi High Court, in the case of Container Corporation, has considered a similar situation where application of the original respondent in the arbitration proceedings for amendment of the written statement so as to make a counterclaim was rejected. Such a decision of the arbitral tribunal was challenged by the respondent under the respondents therein under section 34 of the Act. The Delhi High Court has held that the arbitral tribunal has wide discretion to allow or dismiss an application for amendment of claim of written statement filed before it during the arbitral proceeding. It is held that there is no provision under the Arbitration Act for approaching the court against an order of allowing or dismissing the amendment application. It is held that the petitioner would be at liberty to assail the final award and can take all grounds of challenge as available to it as and when final award is passed by the tribunal. Now, Your Lordship, the final arguments in this arbitration is pending. The final award yet has not been passed. So is this the right stage for assuming that this honorable court has a jurisdiction? Even then, this is not the time when they can assail that order of rejection of their amendment. Now, Your Lordship, these are my two preliminary arguments. On merits, I can make a very simple argument. Lordship may consider that. Even assuming if this honorable court doesn't agree with my first two contentions also, the honorable arbitrator, the learned arbitrator has granted me a certain sum of 74 lakhs. They admitted that 74 lakhs in their initial statement of defense. When I filed a 31-6 seeking judgment on admissions, they sought to amend that figure to no, we have not admitted it. In the SOD, they sought to admit it. The learned arbitrator said, you are resigning from your admissions and I'm dismissing your arbitration because this is an afterthought. But what they filed an amended statement of defense. Then what they did not do, because the 74 lakhs amount is also reflected from their own document, which they have sent to me. And that is the exact amount which the arbitrator has given to me. Now, Your Lordship, the admission, it is settled law that the admission can be extracted not only from the pleadings, but also from the documents of the other side. That document they are still relying on, even in the amended statement of defense. So what is the error of that? I'll just take Your Lordship through those page numbers for Your Lordship may have it. The impugned order of the arbitrator, Your Lordship, at page 32. This has been placed in the paper book, Your Lordship, after page number 669, and in the internal page number, if Your Lordship will see, page 32, which is the last page of the impugned order of the arbitrator.
Page 32 is the agreement, right?
No, Your Lordship, the paper book runs till page 669, this section 34 petition, and at the back of that, they have placed the impugned order after page 669, running page 669. Your Lordship has it? After 669, that order starts. That has
15 July.
15 July, right. Now, Your Lordship may just turn to the last page of this order, which is the internal page 32, where the arbitrator grants me the amount. Your Lordship has it?
Yes.
Lordship, me just see the last page of this order, which is the internal page 32 at the top. The page number appears at the top, 32. Your Lordship has it?
Yes.
I'm reading from the second paragraph. Accordingly, the claimant's prayer, Your Lordship has it? Accordingly, the claimant's prayer for interest is allowed. The respondent is directed to pay the claimant simple interest at 10% per annum for the pre-suit period from 1/11/2021 till 13 January 2024 on both principal amount in prayers A and B of section 31(6) application, the respondent is also directed to pay the claimant simple interest at 10% per annum for pendentalized up to 3rd April 24 for both claims on principal and thereafter pendentalized interest at the same rate up to the date of publication of entry amount on the balance amount of 74,19,900.75 minus 72. 72 they had agreed. So this was directed to be paid. Now the total, what I'm emphasizing here is, Lordship, this is 74,19,990 is the principal amount which has been directed by the arbitral tribunal to be paid to me. Now, Your Lordship, in the unamended statement of defense, they have again mentioned that they are liable for the 74,19,000. So where is the error? Your Lordship, for a moment, have page 301 of the paper book.
Yes.
Your Lordship has it, 30 Annexure G.
Yes.
Your Lordship, this is an email dated 9 December 2021.
Yes.
This email has been issued by the petitioner before Your Lordship to me. Now your Lordship will see there are two tables, and at the bottom it says refundable amount. There are two refundable amounts, 34,04,409.52. Your Lordship has it?
And 40 lakhs 15.
And 40 lakh 15,000. Now, when we add up these two amounts, the figure that has been granted to me 74 lakhs 19,000. This is the exact amount which the arbitrator has ordered to be paid to me. This is their own email that has been issued to me, which says that this is the refundable amount. Now, in the amended SOT, Your Lordship, they again place reliance on this document, on Annexure G, which I just read to the Honorable Court at page 390, para KK. So at one place you sought to resile, but you had mentioned this figure at 2-3 places. You again did not amend this figure, para KK. Your Lordship has it? Yes. Page 390. The respondent has all along showed its bona fide in respect of the contrast between the parties, and by an email dated 9 December 2021. That is the very same email, Your Lordship, at page 301. A copy whereof is annexed hereto and marked with the letter G. Your Lordship may just see this pleading with page 301. This is an email dated 9th December 2021, and this is Annexure G. And this is their amended SOT, Your Lordship, at page 390, which I am reading. Now, Your Lordship, I am just citing Justice Harishankar's judgment of Augment Gold passed in Delhi High Court, Your Lordship. I have just, in that judgment compilation, Your Lordship, may kindly add, at page 177 of the compilation. Your Lord. This judgment starts from page 157, Your Lordship. Your Lordship has it? Page 150. Augment Gold versus 197 Communication Limited.
177 is it?
157, the judgment starts, Your Lordship, and the relevant para is at 177. That's right, Your Lordship. 157 is the judgment where it starts, and the relevant para, Your Lordship, will find at 177.
Para number?
Your Lordship, just above para 63, I am reading, in the context of Order 12, Rule 6, Your Lordship has it?
Yes.
Just above para 63, Your Lordship, in the context of Order 12, Rule 6 of the CPC, Your Lordship has it? In the context of Order 12, Rule 6 of the, it is well settled that the admission on the basis of which judgment is rendered under the said provision is not required to be necessarily to be in the pleadings, but may also be in the documents filed with the plaintiff or even in the cognate instrument. Borrowing the analogy, therefore, a court or an arbitral tribunal which directs deposit of an amount by defendant, which in its view is admitted to be payable by the defendant to the plaintiff, is not acting without jurisdiction or even in an illegal manner if such admission is found to exist in a document executed by the defendant, even if it is not reflected in the pleadings before the court. So this Annexure G, you are again relying in your amended SOD. So where is the error?
Yes.
In fact, Your Lordship, the stand is so dishonest, Your Lordship. When I cross-examine their witness in the cross-examination, Your Lordship, their own witness has once again placed reliance on this very email of 9 December 2021.
Yes.
After the amendment has been rejected. If I can make on, now I'm making the submissions on merits for consideration of Your Lordships. Now, Your Lordship, it is their contention that by way of moving the amendment application, they wanted to interpret certain clauses of the contract. This pleading is at para 13, page 8 of the petition, Your Lordship. For amendment, Your Lordship may have page 8 of the petition, para 13. Evidence Act नहीं लाया हो ना?
Yes.
Page 8, para 13, Your Lordship. The petitioner filed such application not to retract the admitted amount, but seek to interpret the said contract in the manner that it has always understood the same. Now, Your Lordship, this contention is contrary to section 91, 92, and 94 of the Indian Evidence Act, which says a contract which has been reduced into writing, no amount of evidence can be led to interpret the terms of it. It has to be read the way and the manner in which it is written. You cannot interpret a written contract under section 91, 92, and 93 of the Indian Evidence Act. So what is the illegality when the arbitrator holds that there is no need to interpret because this is a commercial contract for supply of coking coal from the petitioner to the respondent. It is a commercial contract thrashed between educated people by the team. So I will read it exactly in the manner, in the black and white that it is written. There is no need for you to seek interpretation of the written terms of the contract. Even otherwise, it is barred under 91, 92, and 93 of the Evidence Act. Your Lordship will find this finding of the arbitrator at page 30 of the award, which is after page 669.
I find substance.
Page 30, Your Lordship has it. Just after the extracted portion. Keeping in view of the aforementioned, I am of the opinion the respondent, Your Lordship has it.
Yes, keeping in view the aforesaid.
Yes, keeping in view of the aforementioned judgment, I am of the opinion that the respondent cannot read into the contract and there is no scope to interpret the penalty clause. And the same should be read as it is without implying anything. The judgment cited by Mr. Gupta in this regard are of no assistance in the facts and circumstances of this case. It is now settled that the merit of amendment can be looked into and considered, and if it is found the reason for such amendment is to resile from an express admission made by him, amendment may not be allowed. Thus, I am of the opinion that the amendment sought for is useless and unsustainable. Therefore, the prayer for amendment is rejected. Your Lordship, for a moment, may also turn to page 29, just the previous page, Your Lordship.
Yes.
The third paragraph, I find substance, Your Lordship has it. I find substance in the submissions made by Mr. Sunny appearing for the claimant that the respondent by their email being Annexure G. This is the exact annexure which I just showed to the Honorable Court. Of to SOD have shown the calculation which is in accordance with stipulations made in clause 4 of both the contracts for imposition of penalty on moisture content and ash content, which the respondent has specifically stated in paragraph 3M and 12, which are affirmed as true to knowledge in jurate portion of the SOD. He submitted interpretation of the aforementioned clause do not require adducing any evidence as claimed the respondent clause. He cited the Honorable Apex Court's judgment in the case of Cartel Infotech Limited reported as 2019-14 SCC 81. The Honorable Apex Court, following their earlier decision, reiterated that the contract to be read as it is. The court has no power to improve upon the instrument which it is called upon to construe, whether to be contract, a statute or article of association. So where is the scope to interpret by way of an amendment a written contract which is a commercial contract negotiated between two business teams of the opposite sides? Now it is one more contention that the arbitrator has wrongly granted interest to me, because in this order 10% simple interest has also been granted to me. Your Lordship, I simply rely on section 31(7) of the Arbitration Act, which provides that the arbitrator is empowered to grant interest wherever the money is found to be due and payable. 31(7) of the Arbitration Act. It is within the remit of the arbitrator. Your Lordship may for a moment have section 31 subsection 7. Your Lordship has it? (31)(7)(a), unless otherwise agreed by the parties, where and insofar as an arbitral award is for payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. A sum directed to be paid by an arbitrator shall, unless the award otherwise directs, carry interest at the rate of 2% higher than the current rate of interest prevalent on the date of award from the date of award to the date of payment. So the arbitrator is empowered under the Arbitration Act to grant me interest, because there is no negative covenant in the contract, Your Lordship, which says under any circumstances the interest will not be payable. There is no negative covenant.
How did the arbitrator deal with the issue of venue?
I'll just read that order. I'll just read that order where that statement is recorded. I'll just read that for a convenience. He said that the venue can be alternatively between Calcutta and Delhi for the convenience of the parties. Your Lordship will also consider, because the parties had also agreed that for procedural hearings in which no hearing is required, parties had even otherwise agreed for VC hearings. That means what? That the Delhi High Court and Calcutta High Court both will have simultaneous jurisdiction. There cannot be two courts having jurisdiction.
Show me.
Yes, I'll just show that order. Page 49 to page 49, Your Lordship may have it. This is the order dated 11th December 2020.
49 of the
49 of the paper book, Your Lordship. Annexure B. Your Lordship has it. Mr. Sarath Kumar Sani, learned advocate for the claimant, has submitted that his client wants to file an application under section 17 of arbitration mechanism for the interim award on the amounts admitted to be paid by the so far as the venue of the proceeding is concerned, it is submitted by him that one sitting will be held at Calcutta and other one at Delhi. Mr. Shayan Gupta, learned advocate for the respondent, submits that he needs time to take instructions from his client. Now, Your Lordship may just see page 51, which is the next order of 13th January 2024. Second paragraph.
Page?
Page 51, Your Lordship.
Yes.
Sorry, I'm so sorry. Page 51, Your Lordship, the second paragraph. It is agreed by and between the parties that every alternate sitting will be held in Kolkata and then New Delhi. So this is in accordance with section 20 subsection 3. It was only for the convenience of the parties and to save costs, because the claimant is situated in Delhi, the respondent in the arbitration, Your Lordship, is situated in Calcutta, and Arbitration Act provides for this. Your Lordship may have the compilation, Your Lordship, for a moment, have page 276. The judgment compilation, Your Lordship.
Yes.
I'm very sorry, Your Lordship. I'm very sorry. Lordship may have page 84. I'm so sorry for
84.
84 of the paper of the judgment compilation. This is the same judgment of BGS Soma, Your Lordship, of Supreme Court, page 84,
Yes.
para 18, where the contract specifies the jurisdiction of the court at a particular place. Only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. In the present case, the parties have agreed that the venue of arbitration shall be Bhubaneswar. This is the same clause, Your Lordship, in my contract also. Venue at Bhubaneswar. Considering the agreement of the parties having Bhubaneswar as the venue of arbitration, the intention of the parties is to exclude all other courts. As held in Swastik, non-use of words like exclusive jurisdiction, only, exclusive, alone is not decisive and does not make any material difference. Para 19, when the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras High Court erred in assuming the jurisdiction under section 11 of the Act, since only the Odisha High Court will have the jurisdiction to entertain the petition filed under section 11. Now, Your Lordship may also have para 82 at this very same page. On a conspectus of the aforesaid judgments, it may be concluded that wherever there is the designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceeding, the expression arbitration proceeding would make it clear that the venue is really the seat of the arbitral proceeding. As the aforesaid expression does not include just one or more individual particular hearing, but the arbitration proceedings as a whole, including the making of an award at that place. So my submission is that the principal court at Bhubaneswar is the only court where they can file a section 34 petition. Now, Your Lordship, in this compilation, Your Lordship, if I may bring your attention to page 123, Your Lordship. This is Bombay High Court judgment, Your Lordship, United India Insurance Company.
23.
Running page 123, Your Lordship. Para 46.
Which is the para?
Para 46 at page 123, Your Lordship.
Yes.
Your Lordship, has para 46. In this case, the initial arbitral proceedings were held at Kolkata. There is also no dispute that no part of the cause of action had arisen at Mumbai. There cannot be two or more seats of arbitration, whereas the venue of arbitration may be more than one, and may be fixed by the parties as well as the learned arbitrator, considering the convenience of the learned arbitrator and the parties. The venue decided by the learned arbitrator to suit his convenience or convenience of the parties for the purpose of hearing of the arbitration proceedings cannot confer the supervisory jurisdiction of such court within whose territorial jurisdiction such arbitral tribunal were held at the venue decided under Section 23 of the Arbitration Act. Under Section 20, subsection 3 of the Arbitration Act, in the absence of the agreement between the parties, the arbitral tribunal has to meet at any place for conducting the hearing at the place of convenience in the matter. In my view, since the entire cause of action had arisen in Kolkata, and even otherwise the seat of arbitration was fixed at Kolkata, only appropriate court in Kolkata would have exclusive jurisdiction to entertain. This is exactly what I am submitting, that by me agreeing to a different venue can be n numbers, it can be 10 venues for the convenience of the parties, but it does not have the effect of altering the seat. This is what is being held in this para 46 also. And your lordship, to fortify that argument, it is their contention that I have waived it. Clause 18, which is the written contract, says there has to be an addendum. Where is that addendum? Supreme Court has held in that Videocon judgment that because the contract specifies for a written signed thing for any amendment or alteration of the agreement, there is a similar clause in my contract also. It has not happened. So just by agreeing to a venue I have altered, it is inconsequential for them to argue. Now, your lordship, today I can contend that the Delhi High Court can also have a simultaneous, because this is what they are saying. Tomorrow I can file a 37 in Delhi High Court. It will just add to the absurdity of what they are arguing before the honorable court.
The rest we'll have it on Monday then.
Monday, if your lordship can grant me the permission to join through VC, if that is, or otherwise I can come also. What subject? Come on, but
Calcutta is a good place. Enjoy Calcutta.
No, not at all, lordship. I'll have your lordship. Great.
Matter heard.
Could your lordship indicate some time
for further hearing on Monday? That I can't do. Affidavit in reply to section 34 is taken on record. Affidavit in reply to section 36(2) of the Arbitration Concession Act is taken on record. Sorry. ये
On my lord, I'm appearing on behalf of award holder. Last week, my lord, director is to inform the receiver, so the receiver can file report regarding the execution of the conveyance of the deed in favor of the successful purchaser. So I have informed the receiver. I'm led by Mr. Sonu Mukherjee.
Has seen, my lord, today was kept only for filing of the receiver report.
This is my report.
My lord, if we can be supplied a copy of the same, or the decretal amount or the awarded amount is still outstanding. This is only a part of the award sum has been satisfied by this sale.
Yes.
Well, maybe get a copy of that report.
Is there another copy?
No, my lord.
Malkan,
I solve next time.
Muller will direct him to circulate, Muller. We'll come back, Muller. The decretor or the awarded sum is not fully satisfied. We'll bring on
How much
record
is the
a
awarded sum?
Muller, today, because there was post-award interest as well, today I have pleaded in my application, it's about 4 crores and odd. By this sale, Muller, we've realized about 1.5 crores.
1.55.
1.55 crores. So the rest is still remaining. The execution will have to proceed. Muller, we'll bring on record all these facts by way for supplementary if Muller so grants us leave.
Report filed by the receiver is taken on record. That this matter be listed. When do you want then? After
Muller will grant us like a supplementary 3 weeks. Muller will grant us in
After 3
case.
weeks.
Yes. And Muller will direct the receiver to circulate the report. Muller.
The receiver is a copy of the same. The report shall be circulated.
Deeply obliged. Muller.
All right.
My lord, my remuneration, my lord.
You have not paid.
The remuneration has been paid.
Long while back.
He's saying you have paid. You haven't
Already
paid.
paid. Huh.
What's up?
The remuneration is fine.
What was it? 500? My lord, only 500 GM before just.
One remuneration has been paid. He wants further remuneration subject to my lord consider.
It's up to Muller. If Muller grants it, we don't stand in the way. As
But
council,
what-
we don't stand in the way.
What was the amount which was fixed?
500 gems, that will come to about 8,000 rupees. 8,000 rupees and all. 8,000 or 10,000. 8,500.
8,500.
Yes. Yes. Muller can direct additional remuneration. Kindly do not record our consent. Muller can direct. As an order of court, Muller will direct us to.
Learned counsel since the receiver has undertaken the exercise of execution of the sale deed and the earlier remuneration of the receiver was fixed at rupees 5,000.
At 500 GMs, gold mohur, that's about 500 GM.
500 GM. This court deems it appropriate to grant further remuneration of rupees.
Whatever falls from Muller. This we cannot.
What
Generally, around 10,000 rupees Muller can direct.
15,000.
No problem.
Good. The same shall be paid within a period of. The same shall be paid within a period of 1 week.
On or before the
Before the date of next year.
Onish, every day.
My application for
Last
enforcement
question,
of
my lord had directed that I bring along the amount, the check. My lord, I have prepared the check, but there has been one error. 2,000 rupees is by mistake. Inadvertently, it is less. My lord, may this check be accepted today? By tomorrow, if it is taken up, by tomorrow, I will either RTGS or demand draft with the exact amount.
I'll take
This
it, my
was
lord,
the-
but
this was the
this is
pending
not
due.
the only pending due. Award is for a particular sum, continuous interest. May I have leave to file a supplementary affidavit, my lord, to show what is the status as of date? And this is not the only part. There was a second part of the award. They had collected money from the bank on a loan taken by me for providing me with a flat, which they failed to provide. So the second part of the award is they have to make good the dues of the bank, and the bank is proceeding in a suit against me, and they are not taking any steps to comply with that. So, my lord, I was also humbly praying for orders in terms of.
But may I, before my learned friend indicates that there are two aspects. From the very beginning, when this matter was taken up, my lord, we have come forward and we have paid the installments in respect of the dues with whatever the amount that was specified in the tabular statement. My lord, with regard to the interest, it was said that since we are paying the principal dues, let that be collected, and as and when the principal is paid, the court will determine the quotient of the interest.
The court cannot modify the award here.
I'm not seeking that. I'm only saying that may the interest be computed in a manner which is bona fide, because I have been paying installments from the very beginning, my lord. My lord, from the very first day, I did not object.
Just to allay my learned
May I
friends,
just finish,
just
my
to
lord?
allay my learned friends' concerns.
Let him finish.
I have shown my bona fide. There was no 34 file. I have come forward and I have started making payments. I required certain time, which is why I had short time. Although I have those time extensions have been granted, but today your lordship have already indicated or made over the payments. I am only praying that the interest portion be taken in a reasonable or in a liberal extent towards me. And with regard to the second aspect,
the interest can be modified.
Well, I am only beseeching with regard to not just the period of the award, but subsequently, because I was making these installments.
You have to make the payment.
I'm
There can't be
willing
any
to.
changes in the interest rate.
Man, I was only requesting if the interest rate or the period, the duration.
You know
the
it can't be
duration.
changed. It can't be changed.
Very well, man. I was only
But
praying.
the
That was
learned
my
arbitrator
that is
has
my
been
submission.
learned arbitrator has been very charitable. No costs. No costs in a case where they allot me a flat, get me to take a loan, take the money from the bank, don't construct. I have to come to court, unregistered agreement. I have to get it impounded, pay 10 times penalty. Learned arbitrator ignores all of that and gives them benefit by not adding that to the award. After that, my learned friend should not be, my learned friend's client should not be.
Learned friend is
And
adding to the award now.
no,
but
I'm not
the
adding
whole
to the
issue,
award.
Again, the
I'm
second
not
part of
adding
the
to the
issue
award.
with regard to the other transaction which my learned friend has mentioned. This is a suit between him and the bank. There is a direction in the award, but even in his tabular statement, he does not make that a part of the tabular statement. My lord kindly takes up his application. The tabular statement is to the extent of 13 lakhs. And today I have paid this 13 lakhs. At least the principal, the entire amount of the principal with the interest that has been indicated in the award, I have paid. My lord, now he has not made a prayer with regard to the balance amount or with regard to the other suit that is pending, where he is defending against the bank. I am not privy to that suit, and I am only beseeching my lord will take up the prayers. There is no such prayer with regard to that amount being made over to him. So, my lord, unless this amount is crystallized and there is any prayer to that effect, then only this will come into the whole picture.
May I?
Total due is 13 lakh something amount.
No. Kindly, my lord, take
that
the
is
award.
what your
My tabular statement says, if your lordship sees, the principal sum awarded is 742.
Yes.
886. Interest up to 4th of July, that is the date of filing, accrued interest is 546. Now, my lord, then this is cost awarded by the tribunal. Then kindly see, I have stated award holders are entitled to further interest at 8% per annum on the awarded sum till realization, award holders are entitled to have the award debtor remit a sum of 955 such and such, together with such further sum as may accrue thereon to Central Bank of India, Salt Lake branch. So it is not his case that it is not the case that I have not mentioned this. Now this is what the award is. Now kindly see the award, the language of the award. The award second part is, I'll come back to the computation. The second part is mandatory injunction. Kindly take page 24. The award is annexed to the tabular statement, but kindly take internal page 24 of the award. Paragraph 41. Your Lordship has seen? Your Lordship is, if your Lordship is looking at the affidavit in support, it's at page 49.
Yes.
A mandatory injunction directing the respondent to liquidate and make payment of the entire sum as may be found due and payable for closing the loan account of the claimants with Central Bank of India, Salt Lake branch, by repaying the loan disbursed by Central Bank of India, Salt Lake branch, with accrued interest thereon in accordance with the up-to-date statement to be given by the Central Bank of India, Salt Lake branch, to close the said loan account, preferably within 30 days from the date of communication of award to both parties, and the respondent will make payment of the said sum so disclosed by the Central Bank of India, Salt Lake branch, in their statement within further 30 days from the date of disclosure, and of service of the said statement of account by the claimant to the respondent. Now kindly see in terms of the award, page 62, I have communicated to Vedic Realty. And the statement which the Central Bank of India gave me is at page 61. They don't make payment of this, they don't comply. Now my learned friend says there is no prayer. Under Order 21, Rule 32, my lord, an order for injunction is to be implemented by arrest and detention in civil prison of his directors. That is the only way I can execute it. There is a prayer for arrest. So either, my lord, his clients say that we will not pay, we will rather be arrested and put in central prison, civil prison, or, my lord, his clients pay.
My lord sees the, now my lord has seen the tabular statement. He had made.
Forget the tabular statement.
I will
See
make
the
the
award.
payment as well. I will
See
pay
the
it
award.
as well. My lord.
See the award.
My lord, I have seen
And
the
my lord,
award. I am not disputing that it is not a part of.
In the supplementary affidavit I filed today, I have given an updated statement from Central Bank of India as to how much is due.
My lord, I am not coming in the way with regard to it being in the award. I am admitting to it. And I have also indicated, but in his tabular statement, after the award is made, he comes forward, files a tabular statement where he makes 13 lakhs as his dues.
No, it doesn't make 13 lakhs as his
My lord,
dues. He
the
also
remaining
talks of-
portion he does not include it, which is why the tabular statement says 13 lakhs 10.
Please, no. Don't try to be extra clever. It's about the award.
My lord.
You have to execute in terms of the award.
My lord.
So whatever amount is due, are you denying that amount is not due?
No, my lord, I have not denied that.
Then?
But with regard to this 13 lakhs, because he has, today, my lord, he has filed an application only with regard to 13 lakhs. For that, I have taken instruction. I have made the payment. With regard to the remaining amount, if my lord directs, my lord kindly gives me some time, I will take instructions as to the time period within which the payment will be made. I am complying. I'm before my lord, I want to comply with the award, my lord. My lord.
Please see the tabular statement.
My lord, in the tabular statement, my lord, that is what I was indicating as well. His indication is only towards the total dues.
Not at all.
But my lord, he makes
not at all.
My lord, then in that case, he would have added that along with the
no need
outstanding portion.
Because that is subject to whatever the dues are with the bank, whenever it is indicated by the bank.
My lord.
And that is exactly what has been stated in the tabular statement.
My lord, he has indicated
so the
that
amount which has been quantified has been given in the tabular statement. The amount which is not quantified to the extent with the bank loan account, that is stated there.
But
that doesn't mean
the only issue is
that doesn't mean you're not going to pay it.
No, my lord, I'm not saying that I'm not going to pay it.
So make the payment. Give me the schedule. When are you making the payment?
My lord, kindly grant me 2 minutes time.
What is this? The current due?
Current due of the bank. Your lordship will take the supplementary affidavit filed today.
Is the 13 lakhs completely paid now?
Yes, my lord.
No. Kindly, my lord, take the tabular, the supplementary affidavit filed today. I have given the full adjustment.
Show me.
Kindly see page 5. So, as per the award we have calculated, Every payment has been adjusted. We have gone adjusting first against the interest and then against the principal. The appropriation is at page 7. If you come to page 5, this is how we've done the adjustment. Today, as of 9th of November, 6,34,000 is due after adding the running interest which is running, and the appropriation is at page 7. They can check, my lord. I can adjust this 554 against the dues, and he has to pay the balance. Check down.
So what will be the balance right now?
So 634 is the balance due. He has given a check today of 554, my lord. Even if I encash this, there is another 80,000 due, and then interest will go on. Even if I
Malad kindly takes up the issue. What is becoming is Malad kindly takes up the tabular statement. In his tabular statement, as on the date of filing, he indicates 13 lakhs 10,000. Malad, whereas when he is calculating in his own statement here,
He's not calculating. There's a 8% interest which is there.
Indeed.
So it keeps accruing.
It keeps accruing. Malad, he has accrued that with the 1310 becomes 1343. Malad, on 4th of August, when the order was passed and the interest was calculated in terms of the tabular statement here and the outstanding
Interest will not stop on the date of passing of the order, no?
Malad, no. I'm not disputing. There will be balance amount payable.
Interest goes on.
I will pay, my lord. That also I will pay. My lord, I am not coming in the way. My lord, what is being made out of me is that I am trying to default, but I am not trying to default. Rather, my lord, I am only saying that I am trying to make timely payments and kindly
You have
consider.
already defaulted. That's the reason the
My lord, there
interest is
was one
accruing.
occasion of default where
You're
there
not
was a
paying
direction.
anything.
execution, his client gave
My
a
lord,
check which bounced.
My lord, the whole problem is that the amount is continuously being modified. My lord,
It
if
has
this
to get modified. It will get modified.
But my lord, the initial directions were not to that effect, which is why today
Sir,
I'm carrying this check.
the initial directions are only to see your bona fide.
My lord.
They are not the amount which has been quantified that is the last payment which you're going to
No,
make.
it is not. It is not. No, my lord. I am not.
The payment has to be made in terms of the award.
Absolutely, ma'am.
And the award is very clear.
Indeed.
So the 8% keeps on accruing.
My lord, the
so even if you
8%.
make the payment today, there's a balance of 6,34,000 which is there, apart from the loan agreement.
My lord. But I will take with regard to if it is only 80,000, I will try to make that payment also within the shortest possible time. I do not wish to have this amount accrue on me forever. But I am trying to pay out.
It doesn't look like that.
My lord,
it doesn't look like.
My lord will only
if you are making the payment, the checks are not going to bounce. So your statement and your glib talk is not really reflecting in your actions.
My lord,
only glib talk. Nothing else.
The issue is, my lord, I cannot indicate.
The issue is make the payment.
My lord,
Give me a time
attempt
frame
has
when
been
you
made,
make the
my lord.
payment.
And my learned friend.
Otherwise, I'll issue arrest warrant, send your guy to jail.
My lord,
I can do that. You want? I can do it.
I'm not coming in the. But I'm only trying to indicate that, my lord, I have tried every effort. My lord will
It doesn't
kindly
show.
consider.
It doesn't reflect. Sir,
Consider my
sorry.
submission. And in this, my lord, my learned friend will not disagree with me with my effort, my lord.
There's a gap between what you're saying and what is being done.
My lord, with regard to the 80%, 80,000, I'll just take instruction. With regard to the 9 lakhs, my lord, I will need some time to make that payment. And I will pay that amount as well.
Indicate the time frame.
My lord, kindly grants me 1 day's time to ascertain and come back. With regard to the 80,000, I'm trying to emphasize
We'll
so that
have
the
it
payment
tomorrow.
is...
Make the
Yes. My lord,
correction in the check. You come back tomorrow.
my lord, kindly keeps it on
Kindly
Thursday.
keep it on Thursday. I
Thursday.
will also not be here.
Thursday, not today.
Okay.
Thursday.
The
Give me a schedule. Give me a
check
schedule
that
of
he
the
has-
payment.
I'm
Give
handed
it back
over
to
the
him.
check.
No, you take it back. Not today.
My lord, then I will try to get the check along with the 80,000 as well.
Yes. Get your client.
You just give it back. You give the supplementary affidavit also
on that day.
On Thursday.
Very good.
Give it back. Not today.
And my lord, the managing director is still present
Let
today.
him be present.
Let him be present.
He'll come. And he was there the last occasion. Well, I am willing to comply and I'm trying my best, my lord.
Sir, let me
At least at my end, my lord, I'm
very
trying.
candidly
Indeed, sir.
that you are making all your best effort in the court. in terms of
Indeed.
your arguments.
Indeed.
But in terms of your client's behavior, the best effort or the best practice is not indicated.
Much obliged, my lord. I'm only to indicate that at least from our end we are trying our best
From
so
your
that to
end,
safeguard his
give me a
interest.
schedule,
My lord.
tell me when you are making the final payment, we'll finish it off.
Absolutely, my lord.
Otherwise, you please indicate if he's here.
He's here, he's present.
If he's here,
Yes,
you ask him as soon as possible, tell him to indicate. Otherwise, I have to take stringent measures against him.
Absolutely, my lord.
All right?
My lord. That is why I've tried to impress upon him, and that's why I'm carrying the check.
No, if he's not impressed, I'll impress him. Where is he? Yes, where are you? Yes, come here. I hope you understand. Give a schedule by Thursday. Or I'll give you my schedule.
Much obliged.
Section 29A application, first extension, the yes.
For respondent number 1 and 2.
The first extension, it is in the stage, our first witness had appeared and he was cross-examined by respondent number 1 and 2. Respondent number 6 will cross-examine him. We are praying.
How many
1
witnesses
year.
are left? 1.
1 year, doing it.
1 year?
Oh, no.
How many witnesses are left?
Our only one witness.
And then they have.
I am opposing it. This
You're opposing it?
Yes.
Tell me,
because Calcutta High Court had no jurisdiction.
Oh, Calcutta High Court has no jurisdiction?
Yes.
Why, sir?
But my lord, the agreement between the parties was not placed before the court.
All right. Agreement was not placed before the court?
No, it was not placed.
It's not annexed.
What was not annexed?
Agreement is arbitration agreement. Where it is given about the jurisdiction.
Are you participating there or not?
Yes.
But that has been challenged before the Honorable Apex Court. I'm placing this order of Honorable Supreme Court.
SLP dismissed, my lord.
Let my lord go through it. Lord, I am reading it. We are not inclined to interfere with the impugned judgment order, which appoints an arbitrator. However, we clarify that the impugned judgment order would not be read as an order indicating that seat of arbitration is Kolkata.
Very good. You go before the arbitrator.
Yes.
Let him decide. You move appropriate application. This is only seeking extension.
And even in the statement of defense, this point has not been taken.
This is only seeking extension, sir.
Yeah, I understand, but the wrong cannot be allowed to continue for a long time at the cost of the litigant.
All right.
My lord, I shall file application to that effect.
No need. No need to file application before the tribunal.
Because,
sir, if you want to challenge, you file it before the tribunal. If the mandate has to be challenged, challenge before the tribunal, not here. We are only looking into the extension or time frame.
My lord, kindly see the agreement.
I'm not looking. This court is not seized of the arbitral proceedings, sir. The arbitral proceedings are going on. Whatever you have to challenge before the tribunal.
Arbitrator is working on.
Arbitrator can hear.
Arbitrator is acting on the basis of the order passed by this honorable court.
That order you have challenged, that has been dismissed. The appointment of arbitrator has been dismissed. Now anything else, go before the arbitrator.
Appointment of arbitrator is not. My lord, kindly see. However, we clarify that the impugned judgment.
Only the seat of arbitration, that is an issue which you can challenge before the arbitrator. Go and talk to him. And whatever application you need to move 14. Sir, we are only looking at the extension of the mandate of the arbitrator tribunal. We are not looking into the disputes regarding arbitration.
My lord, then kindly record my submission and later I will liberty to.
You always have the liberty, sir.
arbitration তো তোমার এগ্রিমেন্টে দেখা নেই এগ্রিমেন্টে জুরিসডিকশন লেখা আছে রাজস্থান
Agreement.
এগ্রিমেন্টে
Not দেখুন না বলছি তো. Not kindly see the agreement.
I don't need to see the agreement, sir. You go before the tribunal, not before me.
This question, I'm afraid whether tribunal will decide this question.
Yes, it will decide, sir. Which section is it?
20.
Section 14, mandate.
20?
No, 14.
Lordship wants to know the place of arbitration.
No, sir, the place of arbitration, you are disputing it. Section 16, competence of arbitral tribunal to rule its jurisdiction. Move an application under section 16. They'll decide it. Read 16. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement. So your validity of the arbitration agreement, the arbitrator can decide. All right?
But in opposition to
Madam, either let him argue, you're confusing him, or you argue.
May I pray one thing? Will your lordship kindly give
Sir,
that?
can you please, you do have the Arbitration Act?
Yes.
Please read 16. Read 16.
Yes. That is.
You are saying the arbitration agreement is, you're disputing the arbitration agreement?
No, not agreement.
Then?
The place of arbitrator.
So go before the arbitrator. He'll decide. This is just extension. Take down.
আরে বলছে তো চালিয়ে বুঝতে পারছো না বলছে যে আর্বিট্রেটের কাছে গিয়ে আর্বিট্রেটের কাছে অ্যাপ্লিকেশন করো বুঝতে পারছো বলছে এক্সটেনশনের জন্য একটা আর্বিট্রেটের কাছে গিয়ে করতে হবে সেটাই বলছি সেটাই বলছি বুঝতে না বলছি আর্বিট্রেটের কাছে
You have never taken this argument before the arbitrator.
Possibly not. I do not know, but
You have filed your statement of defense. Nothing has been taken. In here, you are saying that Calcutta. All right. Take down the petitioner.
My lord, before your lordship, right? I'm just telling your lordship to look into paragraph 18 of Supreme Court decision.
In which context? Which context?
Regarding jurisdiction,
Yes.
where the arbitration to be held. Paragraph 18.
Paragraph
18.
Yes.
My lord, I'm reading. Where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. In the present case, the parties have agreed that the venue of arbitration shall be at Bhubaneswar. Considering the agreement of the parties having exclusive having Bhubaneswar as the venue of arbitration, the intention of the parties is to exclude all other courts as held in swastik. Non-use of words like exclusive jurisdiction, only, exclusive alone is not decisive and does not make any material difference.
This in judgment of 2025 or at the point of election? 25.
Sir, you have filed your statement of defense also. Nowhere you have taken this ground.
That time I do not know what was.
That time you didn't know.
Now, my lord, another 2025 decisions I am placing.
Yes.
It is at paragraph 7.
Yes.
Where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. And if your lordship kindly look into the agreement.
Paragraph 21.2. 21.2.
Sir, I'm not looking into your agreement. Give it back to him. All right, take down. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for the mandate of the arbitral tribunal to conclude the arbitral proceedings and publish the award. Learned counsel for the petitioner submits that the sole arbitrator was appointed by an order dated 10/4/2023, full stop. The pleadings between the parties were completed on
6 September 2023.
6 September 2023.
I stand with 2024. I'm sorry.
6 September 2024. Full stop. Thereafter, what happened after that?
But after that, 28 sittings took place.
By mutual consent, it was extended?
No, my lord. First extension. 2024, my lord,
Yes.
ended on 7 September 2025. Then we have filed.
7 September.
Yes.
The Calcutta thereafter by mutual consent of the parties, the time for The time for conclusion of the arbitral proceedings was extended till 7th of September.
I'll just indicate.
6 months is with the arbitrator, sir. You didn't seek a extension of 6 months.
No. No, after that there was no mutual. It was not possible. I'll indicate, my lord, why it was not possible. Because all the parties were not appearing. Hence, the consent could not be obtained. There are two parties, my lord, the respondent number 4 and 5, they stopped appearing. They first appeared once and then they stopped appearing. That is why there was no mutual consent. Let me just indicate one thing.
Yes.
I believe, my lord, 29A gives 12 months from the period, from the
Yes.
time of completion of
Yes.
pleading. My lord, pleading was completed on 6th September 2024. 1 year from there takes us to 7th September 2025. After that, my lord, since no consent could be obtained from all the parties, we have filed this.
The pleading was completed on
6th September 2024.
क्या लिखा है? वो हटा दो, म्यूचुअल का हटा दो, उससे पहले क्या लिखा? 6 September, full stop. In terms of the act, उसके बाद लिखना उसको the petitioner has preferred the present application for seeking extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the respondent states that the present application is not maintainable. He states that the arbitrator was wrongly appointed under 11(6) and further states that the seat of arbitration cannot be Calcutta, since the contract states that the seat of arbitration will be Orissa. What is this?
Rajasthan.
Full stop. This issue he had taken to the Supreme Court by filing a special leave petition SLP 8700 of 2023, which was disposed of by order dated 10/4/2023, wherein the issue of appointment of the arbitrator was held to be wherein the Supreme Court declined to interfere into the issue of appointment of the arbitrator, though the question of seat of arbitration was left open. Full stop. The respondent has duly participated in before the arbitral tribunal, and the pleadings have been completed. Full stop. Nowhere from the pleading it can be asserted that the issue of seat of arbitration has been challenged Full stop. Even so, the respondent was at liberty to move appropriate application in accordance with law before the arbitral tribunal to agitate the said issue. Full stop. Since the present application is only seeking extension of the mandate of the arbitral tribunal, full stop. This court is of the considered opinion that the learned arbitrator has conducted the arbitration proceedings with diligence, and there has been no unwarranted delay on the part of the learned arbitrator. Full stop. Since the matter is still at the age of recording of evidence, right?
Yes, ma'am.
Recording of evidence. This court deems it appropriate to extend the mandate of the arbitral tribunal to conclude the proceedings before the tribunal and to publish an award. Full stop. The mandate is extended further for a period of
1 year, my lord.
For a period of 1 year for the tribunal to conclude its proceedings and publish an award. Full stop. The learned sole arbitrator is accordingly requested to conclude the arbitral proceedings within the extended time period. Full stop. With the aforesaid direction, the present application is disposed of.
My lord, kindly let me have liberty to raise this dispute before the learned arbitrator.
Yes, you have the liberty. Who's stopping you? You move an application, he'll consider it.
Since it has the arbitration is ongoing.
Yes, you do it.
My lord, has he extended it 1 year from today, my lord?
1 year from today.
Great.
1 year from today, the extension is 1 year from today. Sure.
Lordship, this is my application. Your Lordship would recall on the last day I had concluded a substantial portion of my hearing. If I may kindly recapitulate that in 5 minutes, and then I'll just place one order and I will be done. Your Lordship, this is pertaining to a refund of around 44,42,000 which I had paid pursuant to a tax waiver scheme. This is my post-award Section 9 application. Initially, I had made an application before this Honorable Court seeking directions upon the receiver to make avail of the tax waiver scheme and make the payment for the benefit of all the 5 partners. Now, thereafter, Your Lordship, the receiver did not make any payment. For whatever reason, the matter could not be taken up. Justice Boshak had subsequently taken up the matter after me having availed of this scheme and has passed an order. Your Lordship, I had placed that order before Your Lordship. Justice Boshak had directed the receiver to make a ad hoc payment of 20 lakhs towards put and to satisfaction of my share, and thereafter I had directed to the receiver to make apportionment and pay as per the declared shares of the partners. Thereafter, Your Lordship, since the receiver did not make any payment, they had challenged the order of Justice Boshak before the Honorable Division Bench. The Division Bench has then passed an order saying that, passing 3 essential directions upon the receiver. First is that you scrutinize all the original documents, the bills, KMC payments. Second, you apportion the dues of each of the partners after taking into account of the 20 lakhs that has already been paid to my clients, and file a report to that effect. Now, Your Lordship, the receiver has filed that report. Since my learned friends, senior friends' clients had then filed an exception to the said report, the Honorable Division Bench said that there are 2 Section 34s pending before the Honorable Single Judge. I am not entertaining these 2 applications right now. You take it up before the Honorable Single Judge. In this backdrop, I filed the present Section 9 application, which is before Your Lordships, because the appeal had been disposed of. So with that, the original Section 9 also went. So I filed the Section 9 application before your lordships. And the Honorable Single Judge, Justice Shobhushachi Bhattacharya, had the determination at the relevant point of time. He holds everything in my favor, but at the end he says that because the division bench is order had a particular phrase which state the operation of the balance, that is still operational, and that is why I cannot pass an order in your favor. I prefer an appeal against that order of Justice Shobhushachi Bhattacharya, and today the division bench has ruled in my favor, saying that all that is required to be done is for this honorable court to consider the report of the learned receiver, because the honorable single judge has not done so, and then make the payment as per declared shares. Now your lordship will kindly take the order of the honorable division bench dated 5th November 2024.
Yes.
Yes. Your lordship, the earlier directions that had been given by the division bench are quoted here on the second page, order dated 16th April 2021. The directions are all there. I'm not troubling your lordship with that once again. Your lordship will kindly come to page 3, internal page 3 of the order. Actually, your lordship will come to internal page 4. Internal page 4, second paragraph. It is not in dispute that the receiver...
Just a minute.
Yes, your lordship.
Yes.
Lordship, may I kindly place from internal page 4, second paragraph of the judgment. It is not in dispute that the receiver has filed a report from which the respective liabilities are ascertainable vis-a-vis the parties, and the parties may be directed to pay their proportionate liabilities on the basis of their declared shares. This line alone, Your Lordship, would indicate that all that is required to be done is to simply pass an order directing that the receiver has made and have placed the report of the learned receiver that the apportionment as per the declared shares of the partners are already done. It is not in dispute that we have not paid the amounts, tax liabilities. It is not in dispute that they are liable to pay their respective liabilities as well in terms of the partnership deed. So all that is required, and it is not that they are not enjoying the benefit of the fact that we have availed of the scheme. The original scheme, Your Lordship would recall, gave me a benefit of about 1.5 crores because the liability which had accrued was 1.86 crores, and if I paid the requisite demand within the due date, then it would come down to 44 lakhs 42,000, which I have paid. And it is an admitted position through and through. Now, Your Lordship, if I may continue, the learned single judge, however, dismissed the application on the ground that by reason of the aforesaid observation, which in the order dated 16th April 2021, the relief claimed by the petitioners could not be allowed as it would amount in interfering in the order passed by the Honorable Division Bench. On a meaningful reading of all the previous orders, it appears that the Honorable Division Bench stayed the order insofar as payment to be made to the petitioners by the respondents, since the bills were under scrutiny by the receiver, as would be clearly evident from the order dated 16th April 2021. So this was a temporary stay. However, the report of the receiver was not taken into consideration by the learned single judge on the ground that ultimately there was no finding by the Honorable Division Bench or a specific direction by the Honorable Division Bench to pay the shortfall even after the receiver filed a report. After hearing learned counsel for the parties, we are of the opinion that, keeping in mind the orders passed by the coordinate bench on 16th April 2021 and 28th January 2022, the petitioners may pray for apportionment of liability based on the report filed by the receiver, and in deciding the said application, the objections, if any, by the respondents are also required to be taken into consideration. It would be open for the learned single judge to decide the said application independently or along with the application for setting aside of the award. On such consideration, we set aside the order dated 2nd July 2024. Your Lordship, they have not filed an exception to the receiver's report, at least before this honorable court. They had filed one earlier before the honorable division bench, but they have not brought it back because that appeal has already been disposed of altogether. So as of now, the receiver's report stands. The honorable division bench has passed a direction clearly stating that it may be ascertainable from the receiver's report itself what are the dues and liabilities. Given the admitted position as also recorded in Justice Boshak's order earlier, all that is really needed to be done is for a direction by this honorable court on my learned senior friends' clients to make due payments. And just for completion, Your Lordship, I would once again place the receiver's report, the calculation. Your Lordship will find the receiver's report is in my main application at page 187, starting at page 187, volume 2. And upon scrutiny, the final calculation is at page 193. Volume 2. Now, out of this, Your Lordship, I must indicate I have already settled the matter with one of the brothers, which is Shuk. So the remaining two brothers, Your Lordship, who are my learned senior friends' clients, they need to pay their share. So, which is essentially 4,88,424.60 into 2, whatever that amount comes to. Around 9.6 lakhs.
Yes.
Your Lordship, that is all.
So basically, it is the corporation tax payment which has to be somewhere around 44 lakhs,
That was the total.
which was paid initially
20 lakhs
by
was paid by
Rakesh
the
and Kamal
receiver.
Jindal, right?
Yes, by my clients, the entire amount was paid by availing of the scheme. The
Right.
scheme is also, Your Lordship, is
No, I don't need to see the scheme. Then as far as the report of the receiver, the balance amount of 14 lakh 65,000 has to be
yes,
paid by
yes,
Anup, Sunil, and Ashok Jindal.
yes. Out
Right.
of this, Your Lordship, with one brother, I have settled the matter. The remaining two are my learned senior friends' clients.
So out of this 14 lakh
14 lakhs,
65,000,
Your Lordship will, if we deduct 4.88
Hold.
lakhs, then the remaining, it comes to around 9.8 or 10 lakhs.
9.8 or something, right?
Yes,
That is what you're trying to secure
yes,
by the section 9,
yes.
right?
Yes, sir. Grateful.
Not secure, my lord. I would add one word, execute, which is not permissible. May I just indicate, my lord, the orders? Initially, when I argued, my lord, I took 2 points, my lord. Lordship might recall. My first point is, this is a post-award section 9 application.
Yes.
Execution can't be done.
Yes.
Language of section 9 is itself very clear.
Yes.
Before it is executed, protection will be given. Section 30, sorry, my lord.
Yes.
Section 34 is admittedly pending. One filed by me, one filed by him. I challenge the order award in its entirety. He challenged it partially. Now, what is the purpose of filing this application? That has to be seen. But before that, I would like to place the orders of 2 division bench. It has been placed. I would not place the orders in its entirety, only the relevant portion of the order. Then I would show you the.
Place the order in entirety.
Muller is probably not required, Muller. Subject to what falls from your lordship.
But why have you filed this section 9? What are you seeking? Execution.
Your Lordship, no.
That's right.
If I may indicate,
Just a minute.
if I may indicate, Your Lordship, the reason why I had to give this context was initially I had filed a section 9 before this honorable court seeking direction on the receiver to avail of the scheme. Why? In order to protect the subject matter of the agreement, which is the partnership firm and the property.
That's fine.
Now, in the interregnum, because of the due date, I had to avail of the scheme because for whatever reason, the matter was not being called before this honorable court. Now, good, bad, indifferent, thereafter, the matter was finally taken up by Justice Boshak. Justice Boshak on the principles of restitution, because not only have my clients benefited from this, but also my learned senior friends' clients, because the liability has come down by a substantial amount, 1.5 crores. So, on the principles of restitution, Justice Boshak itself, himself had passed directions on the receiver to pay pro tanto satisfaction. You immediately pay 20 lakhs out of the 25 lakhs lying in your hands. The remaining amount you ascertain, and as per the liabilities, respective 1/5 liability of each of the partners, you pay the amount after taking into consideration of everything. They challenged that order of Justice Boshak. The division bench again passed a direction on them and the receiver, that the receiver is to scrutinize the bills, he is to ascertain the amounts, and then they are to make the payments as per the receiver's report. Instead of making payment,
That's all. That's all.
Yes.
That's all is there.
Yes.
I want to know why you have filed your section 9 today.
Because
what are you seeking?
Your Lordship, I am seeking what essentially now is the refund of the amount that I have already paid.
That's your 34 too?
No, Your Lordship. That is not, it is not a subject matter of the arbitration proceedings at all. The
What is
tax amount that, the tax that I have paid, the tax that I have paid, that was not in dispute or in question.
Entire issue in 34 is regarding the municipal tax, right?
One of the issues, yes, one of the issues.
It is a completely
and
different amount. My learned senior friend would show.
He will, Miller.
Would
Let
show.
me, Miller.
But before that,
show the award.
if I may finish. So, Your Lordship, what the division bench order dated April 2021, and thereafter on 28 January, what had happened was the Honorable Division Bench disposed of the entire appeal, which included my learned senior friend's exception to the report as well as the section 9. So once an appeal is disposed of, liberty was granted, you take it up afresh before the Honorable Single Bench. Because of this, I had to file a fresh section 9, which is the section 9 before Your Lordships.
Yes.
But it kindly comes to his petition, Millet. Let me, Millet, place the award. Because he says not part of the award, I say it's part of the award. So it will come out from the award itself. One of the issues, Millet, is an issue relating to payment of municipal tax. Kindly come to running page, Millet. 121 of the application. Application is AP 117, which is being heard by your lordship, 2020.
Yes.
Lordship has got it, my lord. Paragraph 22, RE 63K. Lordship has got it, my lord.
Yes.
Yes. May I, my lord, please? It is contended by the claimant. Claimant means one of the respondents herein with whom, my lord, he has settled the dispute. And 3 or 4, they are my clients. And that the respondent number 1 and 2, respondent number 1 and 2 before the arbitrator is being represented by my learned friend. Are in that the respondent number 1 and 2 are in occupation of large space of premises and commercially using such space by paying small amount of rent to the firm. In order to ascertain the area in commercial use by the respondent number 1 and 2 and stroke or any partners in the premises and to receive partners sitting was held in the parties were requested to submit chart showing the area and occupation of the respective partners to the premises when they were carrying on business. In the chart submitted by the respondent number 3 and 4, it appears that the respondent number 1 and 2 are in occupation inter area of 1000 square feet in the ground floor and 500 square feet rear side basement in the name of Jindal International Private Limited and 500 square feet in the ground floor at the rear side in the name of Chaudhuri Iron Private Limited, including. Kindly turns over to the next page. International and Jindal Flora rental of rupees 8,000 and 6,000 square feet in the name of Jindal International Limited in the first, second floor, and the amount has been mentioned. Thereafter, my lord, again, some of the companies' name have been mentioned.
So if you are saying that this is arising out of the award, then why don't we hear the award? Why get into
That's right.
section 9?
That is exactly what I'm saying. That is exactly what I'm saying. Now, my lord, just kindly come to the last order of the division bench. He says the order of the division bench is totally in his favor. May not be, my lord.
One which has been handed over.
The last one, my lord, division bench presided over by Justice Sain, my lord. Order dated 5th November 2024.
Yes.
It can't be decided without, my lord, deciding the 34. My lord, lordship has got it. My lord, kindly come to internal page 4.
Yes.
I bow down to your lordship, my lord. Last but one paragraph. On a meaningful reading, lordship has got it. On a meaningful reading of all the previous orders, it appears that the Honorable Division Bench stayed the order insofar as the payment to be made to the petitioners by the respondent since the bills were under the scrutiny by the receiver, as would be clearly evident from the order dated 16th April 2021, which was the order of the Division Bench, prior order. However, the report of the receiver was not taken into consideration by the single judge on the ground that ultimately there was no finding by the division bench or a specific direction by the division bench to pay the shortfall even after the receiver filed the report. Now, what is the observation of the division bench? Kindly read it. After hearing learned counsel for the parties, we are of the opinion that keeping in mind the orders of the coordinate bench of 16th April 2021 and 28 January 2022, I will place those orders relevant portion. The petitioners may, see the language of the may, pray for apportionment liability based on the report filed by the receiver, and deciding the said application, the objection, if any, by the respondents are also required to be taken into consideration. It would be open for the learned single judge to decide the said application independently then or along with the application for setting aside of the award. So it's not that you file an application post-award section 9 and you get an order straight away, because this point was raised and court said it's the discretion of the court to decide this, whether it will be decided independently or with the 34. Otherwise, these findings would not have been there. Now, my lord, the court has referred to the 2 division benches orders earlier. Kindly have a look at those 2 orders. Kindly come to the order dated 28 January 2022, which I believe is the last order appearing at page 268 of the petition. I'm sorry, my lord, I'm troubling your lordship, my lord.
268.
268. Division bench presided over by Justice I.P. Mukherjee. 28 January 2022. This has to be read with this order. Lordship has got it, my lord?
Yes.
Kindly come to the internal page 3 at page 270. court has referred to two applications. Prior to that, Lordship would find one is
which page? Sorry.
page 269.
Yes.
Reference to two IAGA numbers. Lordship has got it. Then the AP number. May I place it from that? The application that is GA number 3 of 2021 is taken out first, and the second respondent in this appeal for a direction upon the appellants and the respondent number 3 to pay them the amounts as paid for in the application as reimbursement of the municipal tax allegedly paid by them. The application being GA number so-and-so has been taken out by my clients, taking exception to the report. Then the court has recorded section 34. Kindly see the last paragraph. Section 34 application are pending in this honorable court challenging the award. A subject matter of the award is municipal tax due and payable by the partnership firm, including the fixation of liability of the firm and apportionment thereof among the partners. And that I will indicate, my lord, from the award itself. I have only placed a portion of the award. Then, we are of the opinion that the subject matter of these two applications can be properly decided in the forum where the final award is under consideration. Then, in those circumstances, we dispose of each of the two applications on the basis of the observations made above, giving leave to the applicants to urge the self-same grounds as made in these applications by way of application or otherwise. So otherwise, my lord, my interpretation is I can do it, my lord, orally also if I can substantiate from the document itself. I need not, my lord, place or file a separate application or otherwise before the state forum. So again, discretion has been given to the court, who will have the determination to decide with or without the section 34. The reason being is very simple, that issue relating to payment of municipal tax was an issue before the learned arbitrator. Now, why they are asking me to make payment? That's a factual aspect of the matter. I tell you, lordship. The reference was made, my lord, because the claimant who has sorted out the dispute, my lord, with this two respondents had an issue and he filed a section 11. Learned arbitrator was appointed. Unfortunately, after he proceeded, he passed away. Another person, designated senior advocate of this honorable court, was appointed as an arbitrator in his place and state. Matter was proceeded with. Interim application was filed for making payment. Yet again, he allowed matter. We filed a section 37 appeal, allowed, referred back. Finally, he passed an award. Now, what did he do, my lord? He has rejected the claim of the claimant, which was a monetary claim. We had a counterclaim.
So, how many claims are there? What are the claims?
Right. Monetary claim of the claimant because of the wrongful and illegal use by these two respondents
of the commercial space.
Yes. And without bringing it to the notice of the partners.
And taking rent and all that stuff.
Absolutely. Directly or indirectly creating some companies and asking.
One is that. Second?
Second is my claim. On the last day I submitted before a lordship, property was leased out. Leased out to 5 persons by the lady who was the owner. It's in Shakespeare Shoroni, my lord. Commercial value is very high. So permission was granted to the 5 brothers to demolish the existing structure and to construct and to let it out. Possibly it was a 999 years lease agreement. Then, my lord, a partnership agreement was executed by and between those 5 persons. Partnership firm was created. Firm constructed the building and developed and let it out. And it was an agreement recorded in the partnership deed, my lord, that one of the partners, all of them, I'm sorry, 5 partners would retain 1 flat each for their personal use. My claim, counterclaim, was that out of the 2 flats, because I represent the 2 partners, 1 flat, my lord, they have taken it forcefully. Why? Because I permanently stay in Delhi. I don't come. So one fine day when I came, my lord, I found lock and key, my lord, was broken and somebody else was in possession. That was a counterclaim I made before the arbitrator, which was rejected, saying that is not the subject matter of the dispute, can't be decided here, relating to getting back possession. Important thing what the learned arbitrator did, and that's why they have challenged their award, which is very important. Though he rejected the claim of the claimant and my counterclaim, he has enhanced the rate of rent. Okay. Meaning thereby, all the occupants who were in possession, they have to pay at a higher rate. In other way, those two partners, they have to pay it because directly or indirectly they're in possession. Either they have inducted or they have created the companies. That was the argument, and subsequent finding was there. So they are aggrieved by that. They have to pay it from their own pocket. Our contention was, till 2000, there was no problem. But after that, when you took control, you inducted those persons, used it for a commercial purpose, and the municipal tax had gone up considerably because of that. So why should I be directed to make payment? I know it is to be apportioned equally because we are, but these things are to be decided and adjudicated. So they filed the 34. They're in possession, they're in occupation, somebody has to pay the municipal tax, and this, they have been doing it. Presently, the receiver is paying, of course, that is the finding of the division, which Lordship has seen is in the last paragraph. Since they had to pay it, because pressure is on them, now they're asking for reimbursement. Now, can that be decided here in section 9 without deciding the section 34? Hear out this, my lord. That was my first point with the 34. 34 will decide it forever, but once and all, my lord, what's the thing, my lord, whether the order stands or award stands or not. And another thing, my lord, that's a very important thing, which is an admitted position also, that this particular claim, which they have made in the form of section 9 application, is, my lord, after the learned arbitrator entered into the reference. So it's a post-award claim, admitted position. If Lordship asks my learned friend, my lord, he will say,
I don't think so he's disputing it. It's a
no, he cannot.
post-award
He
claim.
cannot. Post-award. Now, Lordship knows section 934 or, my lord, to that extent, section 36, when the award reaches finality, becomes a deemed decree. So 9 itself is a protection relating to the award until it becomes a decree. So you get a protection. Now, if it's a post-award claim, which was not argued, obviously, before the division bench, it's a point of law. Post-award claim, can that be decided in an arbitration proceeding, which has otherwise concluded at the 34th stage, or by passing an order directing me to pay? Or, my lord, for that, a separate cause of action starts. It's a fresh cause of action. For that, a 21 notice has to be given. All it's about the award and the reference.
20, no, I don't think
21 notice, because it's beyond the scope of the reference. Lordship would find, my lord.
No, but if you see the scope of section 9, it says during award, post-award. That's the word which has been used.
My lord, language subject to correction, language of section.
Looking any arbitration proceeding as such, it is an interim measure which
No.
we are looking at.
My lord,
So where's the question of 21?
I tell you, Lordship. Section 9, the language, my lord, it starts with, may I, my lord? It's an interim measure. It's an interim measure, language.
It's an interim measure.
Yes. A party may, interim measure relating to what? Relating to an arbitration proceeding which is pending.
No.
Kindly have a look at this. A party may, before or during the arbitration proceedings,
Yes.
or at the time after making of the arbitral award.
Yes.
So there has to be a reference.
Or at any time after making, sir.
Or
please.
at any time after making the arbitral award.
Yes.
Kindly see.
Yes.
But before it is enforced in accordance with 36.
Yes.
So it has to be award, and the award need not be.
This is exactly what the stage is today.
Yes.
It is a 34 award which is already there. There is no execution proceeding.
But their claim is post-award claim.
It can always. That's what section 9 is. Sir, what are you saying? You read it properly again.
Very well, Miller.
Let us read it.
A party may, before or during the arbitral proceedings,
during, or at any time after the making of the arbitral award. That is 34.
Yes.
But before it is enforced.
Before it is enforced in accordance with section 36.
Correct.
So section.
So this is the time. He has moved it during this period. So as far as maintainability is concerned, that's not the question. Whether any order can be passed or not, that is something which has to be seen.
My first point is still there, but with this
maintainability is not a problem.
Milord, kindly, Milord, just Milord, thinking aloud, Milord, I may be wrong.
No, I mean, we are reading
Absolutely,
it together.
absolutely, I may be wrong. My understanding, Milord, subject to correction, before it is enforced in accordance with section 36. Section 36 is a deemed decree. when the proceedings come to a finality. Proceedings means which started.
So you also know that a deemed decree in terms of award definitely has different connotations also.
Yes.
It can't be specifically read as CPC.
Yes.
All right. That is the reason why we have, this can be enforced in different places.
Yes.
So those, there is a distinction.
Yes.
So 34 to 36 in between 9 can be filed.
But relating to protection of something which is part and parcel of the award, which has not been enforced in terms of 36. Now, what is his claim? That is after the award was passed, maybe relating to the municipal tax. But if you see the nature of the award, the learned arbitrator has made a direction to make payment relating to municipal tax, which is under challenge. Now, this particular claim is after the award was passed. So it's a fresh cause of action. That is exactly
That
my
argument is impressive.
That is exactly my point. I'm grateful to your lordship.
That is a subsequent charge
cause
which
of
has been raised on the property. Then I'm not going to look into it because that is not the subject matter of the arbitration procedure.
Now, my lord, what happened? I'm grateful to your lordship. Now, my lord, there's a partnership deed which contains an arbitration clause. It's a dispute.
It stops between that period.
Absolutely.
Whatever charges have been
Absolutely. I'm
raised,
grateful
that
to your
bill,
lordship.
Beyond that, we are not traveling.
Absolutely. I'm grateful.
Beyond that, we are not traveling.
Absolutely. That's my point.
If that is beyond it, sir,
Admitted position. Admitted position. He cannot dispute that.
We are not getting.
Kindly ask him when the payment was made and when the cause of action arose. That's an admitted position.
If you are in the section 9, you are asking for any of the payment which is subsequent to passing of the award or any of the bills which has been raised by the KMC after passing of the award, we are not looking into it.
This is my first point. Other point remains. Kindly ask him from the record.
If I may, perhaps your lordship, I can convince your lordship otherwise.
Sure,
because
I mean, you're all at liberty to
if we may once again read section 9, because your lordship, the entire purport of this section 9 after is to protect the subject matter of the arbitration, even if the cause of action for
the matter of the arbitration is only to the extent where the contract is, and the contract, if it has already sealed or seized of the amount which is being under in dispute,
because in that case, your lordship will kindly have to appreciate what was the subject matter of the arbitration agreement, which is the partnership
cannot
deed.
be stretched. The subject matter of the arbitration, according to me, would have been the amount which is during that period, whatever it was raised. When you had moved it, it was 1 point something crores. During the proceeding, you had moved to section 9 where there were orders which were passed where it was reduced and the receiver was given the liberty to make the payment in terms of a scheme which was there. Under the scheme, that got reduced to 44 odd lakhs. In 44 odd lakhs, now you have settled with one person. What is left is 14 odd lakhs, which is to be paid between two people, right? So 9 lakh something amount has to be paid as far as the other two are concerned. Any subsequent amount, whatever it is, cannot be looked into by this court under section 9.
Your lordship, if I may kindly be allowed to persuade your lordships otherwise. If I may kindly please section 9 once again. A party may, before or during arbitral proceedings, or at any time after the making of the arbitral award, but before it is enforced in accordance with
So what is an award?
Now
What is an award?
The award is, your lordship, the final
culmination
adjudication on the dispute between the
based
parties.
on a contract.
Yes, based on an agreement. Now, section 9, subject to correction, your lordship, is a remedy that I have in order to protect the subject matter of the arbitral proceedings, which of course emanate from the contract. What is the contract? The contract is the partnership deed between the brothers who have agreed to do what? To develop the property which is at 10B
So when we file a statement of claim,
yes,
all our claims
are
given in there. That A, B, C, these are the things which we want. This is the subject matter of dispute.
Correct.
Dispute is never open-ended.
Correct. Now, your lordship will take it from me. The statement of claim is not annexed here, but the entire dispute was nothing but the partnership form, the property in the firm, because they are saying that we have unlawfully inducted tenants and that we have fudged accounts of the firm.
One of their claims was, of course, whether or not the partnership deed is to be dissolved. That has been ruled against my learned senior friends. As far as the tenants is concerned, that has also been given against them. The finding is against my learned senior friends' clients. As far as fudging of accounts is concerned, even that finding is against my learned senior friends' clients.
Let us see your application.
Yes. Your Lordship will kindly take up my application. I am not disputing, Your Lordship, that my cause of action has arisen after the award has been passed. Admittedly, no. If I may kindly,
this claim is concerned.
as far as my post award section 9 application is concerned, my dues all emanate from 1980s, around 1985, 1986. So that runs throughout the period when the disputes have been there during the arbitral proceedings through and through. As far as municipal taxes are concerned, Your Lordship, my learned senior friend has not placed any paragraph which would show that even the payment of municipal taxes was for consideration before the learned arbitrator, and that was not the case. What my learned senior friend is referring to.
Section 9,
yes,
you are saying you're admitting that the dues are after the passing of the award.
No, my dues, my original principal dues are much prior, from 1985, 1986. After the waiver scheme, yes, after the waiver scheme, I am in no position to deny. The waiver scheme came in 2020. I have had to make the payment within February 2020 in order to avail of the benefit, which I have. For that, I had made the application, and for that, I have paid 44 lakhs and all. But why had I made that payment was in order to protect the subject matter, protect and preserve the subject matter of the arbitral proceedings, which is the property. Because if I don't pay now, the entire property will go under lock and key. All us five brothers will lose our business. We will be sitting hand in hand. We will not have anything to do whatsoever. So in order to protect and preserve the subject matter of the arbitral proceedings itself, which is the partnership agreement and the property, which it was agreed that the five partners would commercially exploit and take benefit of, I had made the Section 9 application. And now, Your Lordship, I have 3 orders in my favor, one by the Honorable Single Judge as well as two by the Honorable Division Bench. At this stage, my learned friend, the last order passed by Justice Shoman Chen Division Bench, that has attained finality. My learned senior friends have not challenged that whatsoever. So, with clear-cut directions by the Honorable Division Bench, my learned senior friend, in my
Where are the directions?
in utmost humility, Your Lordship, cannot persuade Your Lordship.
First,
Sorry, Your Lordship.
Show the
all points
directions.
are kept open.
No,
I'm
not
wrong. All points are
Your
kept
Lordship,
open.
my learned again.
not been
Your
touched
Lordship
with
will
any
kindly
document
take the order of the Honorable Division Bench. Yes,
Not
the
been
order of
touched.
28 January 2021. It has dismissed my application for apportionment and the exception filed by my learned senior friends clients, saying that since it is in consideration before the Honorable Single Judge, the Section 34, you take it up before. Now, Your Lordship will kindly take the award, portion of the award which my learned senior friend is relying on to assert that the particular portion of municipal taxes was in dispute. Your Lordship will kindly take.
Not place the entirety.
Yes, I will place it. I will place it. Your Lordship will kindly take the award. It is at.
Milord, to cut it short, Milord, I'm sorry. Lordship would kindly come to page 143. The operative portion of the order. I wanted to place some other paragraphs
No, not one.
relating to show that's an issue. 143.
143 is section.
Sorry. 143. No, I'm sorry.
128. Your Lordship will come to 128.
I will indicate. Yes, 130.
Yes.
And the last one at 131, there was a direction upon the receiver to make payment that is relating to the municipal tax.
Yes.
Which they have, and that I can show it from the award itself.
Yes.
And that would be evident at 127 also. This cannot be disputed cannot be disputed. There are other claims all indicated. Part of claim which was allowed relating to payment of municipal tax. So under challenge. Now with subsequently paid, which he admits, but possibly can't be done.
Your Lordship, this particular payment was made only pursuant to orders of the Honorable High Court in a separate proceeding writ petition. Because of that payment, I had filed a section 17 before the before the learned arbitrator. It is pertaining to certain electricity and payment of electricity charges and other ancillary charges. I have paid again. It was an admitted position. The finding of the section 17 application, your lordship will kindly find at page 142, same volume 1. This was ultimately given, and this has. Yes, your lordship will kindly come to page 142. The second last paragraph, 7 lines from the bottom of the second last paragraph, such being the position. Your lordship is found it?
Yeah, the 142, right?
Yes, your lordship. Has your lordship
Such
found?
being the
Yes.
position, the objection as to maintainability.
The objection as to maintainability is rejected. The other objection is that the subject matter of the application is not the subject matter of reference, and therefore no interim order could be passed by the tribunal in view of section 21 of the Act is also meritless. In my opinion, as discussed above, permits the petitioners to maintain instant application for relief paid for. The objection is also rejected. Thereafter, your lordship, paragraph 17, the payment of corporation tax in the sum of rupees 15 lakhs and 36,660 were made in pursuance of the order of the Honorable Court dated 28th April 2016. The factum of the order cannot be disputed. The payment of the sum supported by the receipts also could not be disputed by the respondents. Electricity charges paid by the petitioners supported by electricity bills could not be disputed by the respondents. It is undisputed that the property in question is on long-term lease and the lease rentals were to be paid, and such rentals had been paid by the petitioners. It is not the case of the respondents that such lease rentals were not paid for the period such and such. It is pertinent to note here that other than the payment of corporation tax pursuant to the order of the Honorable High Court, all other expenses by the petitioners on account of lease rentals, electricity charges, taxes were incurred at a point of time when the present receiver was not appointed, and the erstwhile receivers appointed by the Honorable Court did not take effective steps to collect rents and pay the costs of the maintenance of the property. This is also not the case of
spent on this. We could have finished 34 also.
My lord,
Your lordship will
if
kindly
there is a
consider now.
fate of the 34.
I'm saying the amount of time we have spent on this.
Your lordship will now kindly consider this.
Absolutely.
The payment that I had made was pursuant to an order of the Honorable High Court in a writ proceeding, separate writ proceedings. The payment that I had made in February 2020.
Well, out of the court, I'm saying should have been sorted out between the 5 brothers.
Actually, it's a small. It's not a very big amount.
I do not know why the brothers are not.
No, but I tell you, area and the building. Area and the building. One takes advantage of the fact that the other one stays outside. That's a fact. That's a fact reality.
This is the stance, your lordship. Then
I was there in the arbitration. Fortunately or unfortunately, I tried personally, didn't walk out. Out of the court, I'm saying. One had sorted out because he stays in Calcutta. This could not be sorted out because these two gentlemen, they stay in Delhi.
So they feel that if they're not using it, they should not pay.
No, it's not that. There has to be a total settlement.
Total settlement of the
total settlement.
They are agreeable to take all their assets but not to meet their liability.
I tell you, lordship, question of meeting the liability will obviously come. But think about that. It's a 5-storied building in Shakespeare Shoroni.
It's a good area.
Lucrative. And one of the posh,
pardon my...
Absolutely. Now, 50% of the building is in their possession directly or indirectly. They are afraid of paying the enhanced rent. They have challenged the award. From the enhanced rent, it could have been paid. They refused. Refusal is very clear. Because you are not paying it, tenant will pay. Why did you file 34? Absolutely clear and simple answer. Because directly or indirectly, I have to pay. And what is my position? I stay there. I can't come and contest.
Yeah, spent so much time. Why don't we hear the 34 also?
Yes, lordship can decide it. Lordship can hear out the 34 fixing a date. But with regard to the fate of this application, I have my doubts relating to the present claim, whether this can be decided.
We will decide all.
Very well. Decide it, my lord.
That your lordship.
Keep the maintainability point open because admitted position, what they say, post-award can't be done.
But your lordship, today perhaps maintainability, the point of maintainability cannot be raised by my learned senior.
Beyond
your lordship, my senior friend has already taken up the point twice. It has been ruled in against my learned senior friend.
Since I've understood this, why don't we do one thing?
And I tell you one thing, but probably lordship will takes it up. The principal point, the point which we wanted to argue, we have taken it in R34. there is a clause for in the partnership deed. If somebody wants, he can go out. We say dissolution of the firm because that clause is there. Because after all,
What is kind of right of first refusal to buy or the share or just go out?
no.
Like going out will
But
not
I would not be able to tell your lordship all the clauses. One is there, you can leave. I say you dissolve and give a true or faithful account, which is normally happens in a suit, my lord, under the Partnership Act, lordship knows, my lord, up to section 34, dissolution by the court also. A true faithful account has to be given because after all, allegation is one partner is taking benefit of the position. So the account has to be given. Give me my share, I would leave. So what the learned arbitrator did, my lord, he said the firm has to continue, business has to continue. You have no claim, but all other statutory, if you want to leave, you can leave, you may continue, choice is yours. But he did not dissolve the partnership firm. On the contrary, he enhanced the rent. He said it has to be met with, this has to be done. Position was you were in possession.
Can he do that?
Hello?
Can he do that? The enhancement of rent.
Yes, there is no bar. There is, with greatest of respect, the issue was relating to when he says the firm has to be there, the protection has to be made. But I'm not going into the deep into the matter. If you say the firm exists, obviously there has to be a quantification of the rent.
Your lordship, there was no claim to begin with. That is the entire issue.
There has to be a quantification of the rent because one of the issue was there was not adequate fund in the hand of the receiver. So who will pay? They're saying, I am paying. You ask others to pay. We said, we have no money. No money so far as this particular business is concerned. We are not getting anything. So why should I be held liable? Then what option he could have had? He had to enhance the rent. Enhance the rent because from the enhanced rent, these expenses and statutory outgoings all can be met with. They objected to that. I have points to argue about the resolution why it can't be done. But for that 34, I think affidavits are complete with regard to the 34. It can be,
but not with my 34.
Their affidavit. You file your affidavit.
In my 34, my learned senior friends haven't filed their affidavits.
I think we
in
have.
In their 34, we have exchanged affidavits.
If it's not done, lordship will fix a date. We would file on instruction.
Affidavits have not been filed.
34. 34. 34. No. Matter has not been heard. Oh, my advocate on record says it's only been filed. It never appeared in the list, not taken on board. I do not know. But we can file an affidavit. Lordship can treat this matter appearing as on the day's list. He can give the number. I'm giving my consent. I would file my affidavit. No problem at all. Without this, it can't be decided. And of course, this point, I know. Post-award, I have my sincere doubts for it. But here out everything
will kindly just decide this. I will just give a quick 2-minute reply. That is all that is required to be done, at least for this.
Not be sorted out. What has fallen from your lordship, my lord, I can understand.
If your lordship is very desirous that they be heard together, then I will no longer object. It's just that I only need
point is on the basis of his admission can't be decided at all. This post-award claim. The rest can be, of course.
In this pleadings are complete, huh? This application.
This application, yes.
Anything else?
Yes, your lordship. Only thing is that again, I would at the cost of repetition, this section 9 application was only filed afresh pursuant to the order of the Honorable Division Bench on 28 January 2022, because the Honorable Division Bench said you once again you approached the Honorable Single Judge, and he had disposed of the appeal. So with that, my section 9 application also went. So I had to file the section 9 application afresh. My original section 9, which is why I was compelled to file a supplementary affidavit, and the entire explanation has been given over there as well, was only in order to seek directions on the receiver that you please avail of the scheme in order to protect and preserve the subject matter of the entire dispute, which is the partnership firm and the property of the partnership firm. It is not in dispute that the partnership firm and the property of the firm was not in dispute. The allegations that they had raised in the statement of claim was regarding to fudging of accounts, unlawfully inducting tenants, and of the sort. Both the claimant had made the original claims, and my learned friend's clients had supported the claimant. This was the sum and substance of the dispute. As far as rent component is concerned, your lordship will take it up when the section 34 is taken up, but it was not even a part of the claim. Arbitrarily, the learned arbitrator had fixed an enhanced rate of rent, which is why I had challenged it. Now, be that as it may, your lordship will kindly only consider that my cause of action has arisen pursuant to the waiver scheme only after, because the demand was made after, but the demand was made apropos the dues which had accrued much prior to even the disputes which had arisen between the parties. And since about 2002, subject to correction, about 2002, at all material times, the property has been under the possession of the receiver. Earlier, the receivers did not take any steps whatsoever to meet the liabilities. Thereafter, because of which all the dues have accrued, the disputes had commenced already. We had made a section 17 pursuant to another proceedings in which the High Court had directed us to make payment of electricity charges, because there are tenants, of course, including us.
17 was allowed.
Yes, the section 17 was allowed. There is also a dispute in that regard.
You
Yes.
just read it out, the maintainability
Yes.
and other things were raised, but that has been allowed.
Yes, and that was
allowed
ultimately given.
Appeal. We challenged that order of 17.
What is
Appeal allowed. Remanded back.
Remanded back.
Yes, finally the learned arbitrator held
What was the ground on which the appeal was allowed?
that, I can't, faintly what I can recollect,
because he had raised the ground of maintainability and other things.
no, the first 17 was relating to an interim protection, which, like section 9, approached the learned arbitrator to pay off. Possibly the Honorable High Court said, when we take it in appeal, that at that juncture, the learned arbitrator, without going into the other aspect of the matter, could not have passed a final order which is in the nature of monetary decree to say that. It's an award. He directed the two parties to pay off certain sum of money. When evidence was going on, disputes have been raised. Such an order is basically a mandatory order, in the nature of mandatory order, could not have passed. So he remanded, and the learned arbitrator did not do anything. They accepted. Finally, when the award came, that monetary part he has included and directed us, which I showed you, to pay.
Yes.
And of course, the tax component is there. That's on another. If I have only placed J, K, or L.
The award is of which year?
Lordship, 2019, 23rd December 2019. Now, my only submission, your lordship, is that the particular amount that was awarded.
In fact, we mentioned the matter, but unfortunately, because of paucity of time, my lord, section 34, my lordship knows it takes some time. So it appeared.
Nobody argues 34. In 2 weeks, I have not seen anybody argue. Every day I'm pushing lawyers to argue 34.
Lordship can take up this matter along with the other matter. At least it's a point to be decided, Millard. I may lose, I may win, but a point to be decided. And I think subject to correction is a good point, whether dissolution can be done or you direct the firm to continue. When one partner, in terms of the arbitration clause.
Yeah, but the pleadings are not complete. The problem.
So far as my 34 complete, as I submitted, Millard, I'm not very sure. My advocate on record says their 34 never came up, never taken on board. So if my learned friend can give the number, lordship can pass a direction. I would file an affidavit, both can be heard together. And since he is insisting for deciding this section 9, Millard, I take the 2 points. First point, of course, was admitted position, Millard, possibly beyond the scope, Millard.
Your lordship, the admitted position is that I have made the payment after. I have made the payment after, pertaining to dues which are much prior. Your lordship, I can show the dues as well. It is there in the demand. All the periods are given, leading to an approval. Yes, your lordship will kindly take volume 2.
Yes.
Of my application.
Yes.
Page 151. 150. Page 155. At page 155, your lordship will find this is the demand that was made by the KMC with the letter of intent. The dues your lordship will find 1974, 75, 82, 155 volume. 79, 80, 82, 83, 88, 2002, 2008, and then goes on.
All right. Anything else?
Your lordship, that.
Heard.
And just for conclusion, Lordship, today with the in utmost humility again with the division benches order there, perhaps your Lordship can my learned senior friend can no longer take this point because he has taken this point before the honorable division bench and the single bench, and on both occasions
Where I
point
have
of
taken
jurisdiction
this
has not
point.
been. Yes, my learned
Where?
senior friend has
The orders that is
where I have
reflected.
taken the point on
the
the
senior friend has
contrary.
has argued this
His
point.
orders, I didn't see that he has taken.
No,
this
no, no.
point.
On the contrary, my lord, may I just, since he is
We'll
insisting.
take it from me. Perhaps it has not been recorded, but he has argued this point.
Page 270, my lord, Lordship sees the first order.
Show me that.
All points
Which
where I have taken, just show you.
No, my learned senior friend has argued this point. It has not been
possibly have
recorded, but
argued,
he
not
has
recorded.
argued this point.
court just declined.
Nothing there. And my lord, if Lordship sees all points, the page 270, again, I'm troubling your Lordship, order dated.
Court was not impressed with this argument.
Absolutely. 28 January 2022 order, 28 January. All points.
I didn't see it. I didn't see it. I also read the order.
No, it has not been recorded.
But I tell you, Lordship, when this was taken up before Justice Shompa Sarkar, while arguing this point came up, it's a point of law. It's beyond the scope. It can't be done. And all points are kept open. That's the finding of the division bench, order dated 28 January. This will probably go against
Scope of award can't be extended.
Can't be.
No,
Even by the
this
division
is again, this is to protect the subject matter on which the award is being passed. This is not
That is what the purpose of
My lord
interim
is
measures
saying that-
are, to protect the subject
Yeah.
matter. But is this the subject matter?
Relating to what the protection will come.
We have to
should
see
be of
that.
the
We'll see
arbitration.
that.
Very.
We will see.
But my first point, the other point also, if this can be, but possibly after this, my lord.
CAV. CAV. Alright, CAV. The rest of the matters tomorrow.
Wait.
Yes.
Next matter, my lord.
Want to do it?
An interim order passed, my lord. Settlement talks are going on between the parties.
Call out
My lord is kindly.
Call out the next matter.
My lord, I am bringing respondent number 1.
I appear for the petitioner, my lord. This is a section 9 application. There was a risk of alienation of property and interim order was passed, my lord.
And my instruction is my talks of settlement is going.
Yes.
Learned counsel for the parties submit that the settlement talks are underway. They pray for a short adjournment. Learned counsel for the parties state that settlement talks are underway. They pray for a short adjournment. Let this matter be listed after in the monthly list of January.
My lord, December 2 weeks. In January. Then,
It seems the talks will fail right now if you can't come to a conclusion of date.
my lord, 3 weeks.
Seems
My instructions are it's nearing completion. If my lord kindly lists this after 3 weeks, my lord.
after 4
we'll-
weeks. 4 weeks.
My lord, the interim order may be extended till such time at least.
But there is
There is an issue of alienation of a property.
Where's the interim order?
My lord, the interim order was passed on 30th January 2025.
30th January 2025.
My lord, the arbitral proceedings has commenced because
shall continue up to 30th April 2025. Thereafter, my lord, never.
yes, my lord, thereafter, my lord, there was a direction for implement, my lord, that protection. There's a risk of alienation of property, my lord. If that
has never been extended further. After 30th of April, there are orders which are passed. Time and again, no extension has been granted.
No, that has not. But my lord, may I just say one thing? Section 9 to my lord permits the court to extend the order, my lord.
Does permit, sir. I'm not saying that. If you are under the fear, you come back.
Is it my lord's pleasure that we file a formal application seeking? We'll do that, my lord. Grateful, my lord.
The talks are going on. Where's the question? We must
My
be
lord,
sorting it out.
talks are going on, but my lord, but just for our protection, the developer we are up against, my lord. That is the reason. There was a allocation towards the owners. We apprehended that was being sold off. When we approached, the doors were locked, were not given access. Appreciating that facts, my lord, the learned single judge had granted us. I'm sorry, the honorable court had
The interim order granted earlier.
on 30th January 2025.
January 2025 is extended further for a period of 6 weeks.
Grateful, my lord.
You'll have some pressure.
Grateful.
That might help in your settlement.
Grateful,
Your
Lord.
Lordship,
So grateful.
Lordship, the next item, item number 6, Your Lordship, it's a very small matter. The matter has been settled between the parties, Your Lordship. Just they are awaiting the NDC. Lordship kindly directs if the matter reappears after 10 days. In the meanwhile, we'll provide them the NDC. They are for the
Take down. Item 10.
Item 6. Item 6.
Learned counsel for the parties submit that the settlement talks are under.
Lordship, they have paid the settlement amount in full. Just they are awaiting the NDC.
This is the learned counsel for the petitioner states that that the matter stands settled.
Lordship, and we, Lordship, I am for the respondent. Lordship, the finance company. We have also put in our EC was filed in 25. We have also put in the mentioning slip to withdraw that EC as well, along with the communication.
So I'll just
Lordship.
I won't record anything then. Let
Okay.
me just give a 10 days. At the request of the parties, let this matter be listed after 10 days.
Lordship.
Give a date after 10 days.
I'm grateful.
Much obliged, Your Lordship.
My lord, item 7, my lord, I am only to give the copy of the petition. My lord, let me give the copy only. This is
Item
the
7.
item.
Which
I-
copy are you giving? What are you?
The of the petition of appointment of
This is for appointment of
section 9 application. Your lord.
Section 9.
Section.
Take down. Learned counsel for the petitioner has handed over a copy of the petition to the respondent.
Respondent.
Respondent number, only one respondent?
One respondent.
Respondent. Full stop. Respondent seeks and is granted. You want to file reply?
We'll file a reply.
Respondent 21. You want to file reply?
Yes, my lord.
Seeks and is granted 2 weeks time to file his affidavit in opposition. Let this matter be listed after 4 weeks. Two weeks is enough to file your reply?
Yes, fine.
I mean,